September.
Not 7th. On request made by the parties. This the matter after 3 weeks.
Well, a date may be given because we have some urgency in this case, Lordship.
Then why are you adjourning the matter? 14th.
14th. Obviously, Lordship.
May I please, your lordship?
Uh,
May I please, your lordship? Also, beg to mention for listing a motion matter, lordship. Tomorrow, lordship.
why tomorrow?
Lordship, urgency is that we have challenged an amalgamation order, lordship. Urgency is that lordship, respondent authority may implement the order. Therefore, lordship,
Monday.
Sunday. Obliged, lordship.
May I please, yes, Lordship, I beg to mention for a petition for listing and admission on 11th of September.
Okay.
Okay.
May I please, your lordship, I pray for listing in admission, lordship.
Mm.
Matters regarding constitution of the SMDC, lordship. The lordship may list the matter next week, any date, lordship.
Yeah. 8th.
Obliged, lordship.
8th September.
One of daily list.
May I please, your lordship.
Where's your friend?
Yes, I'm fine. And is this matter already been, completed? Yeah.
Why was it adjourned? The
Last occasion, on the date of delivery of the judgment, lordship, opposite side lordship made a submission there. That petition 1 to 3 are not compassion appointment. How she will controvert? They are not controvert.
He wants to file an additional affidavit.
Want to file a decision.
Has she filed the additional affidavit?
No,
Where's the counsel? We take out after some time.
lordships.
Two of daily list. Motion.
May I please, your lordship. Lordship, this matter pertains to compassionate appointment, lordship.
Oh.
The father of the petitioner died in the year of 2015, lordship. Accordingly, he applied for compassionate appointment, lordship. That is on lordship, the 17/2015, lordship.
Oh.
But his case was not considered, and there was no revision order issued by the DLC as per subclause D of the clause 24 of OM dated 1/6/2015, lordship. Now, also after filing of the present writ petition, lordship, the Deputy Commissioner of Nagaon, lordship, to have the file an affidavit, lordship, in opposition, lordship.
Oh.
And why did affidavit, lordship? By an DLC dated DLC, lordship, held in the year of 2016, lordship. This case was taken into consideration, but lordship, due to want of vacancies, it could not be considered, lordship. Lordship will find that DLC, lordship, of the affidavit in opposition, lordship, at page 34. And relevant person, lordship, that is
Page
at
30?
34, lordship, of the affidavit in opposition, lordship.
Yes.
And lordship, relevant person at page 43. At serial number 7, lordship.
Serial number?
7, lordship.
Yeah.
This looks so legible, lordship, even the lordship. At like for duty, not lordship, son of let. Who Lord her not lordship. The remarks, lordship. Want of vacancy.
Who appears to state? Government?
I'm informing something.
Who appears? Yes,
Lordship, in this method, G Pegu will be appear, Lordship. After
where's
some time.
Begu?
I-
After some time for it.
After some time, Lordship.
Saika is there? Saika, are you appearing?
My lord, paragraph number 4, my lord.
That is-
PLC has rejected due to want of vacancy.
Oh,
In 5 also, my lord. Since there were no vacancies in other department, at the time, therefore the name of the petitioner could not be considered under paragraph.
You applied for which post?
Great for lordship. They examine only one DLC lordship, though it is required to examine up to 2 years lordship from the date of the making application lordship. And by paragraph 15 lordship, okay, 5, sorry lordship.
Huh?
By the at the paragraph 5 of their affidavit in opposition lordship,
Hmm.
they stated that so and so that it answering the opponent backs to state that since there was no vacancy in any other department at the time at that time, therefore the name of the petitioner could not be considered under paragraph so and so or so and so. It is only for one time lordship. Only for one DLC lordship.
Where is the provision that it has to be considered after 3 years?
Up to 2 years lordship, that is the principle 10 of the clause 11 lordship of OM lordship, that will find that lordship of my writ petition at page 23 lordship. Sorry lordship, at page 21 lordship. Principle 10 of the clause 11 lordship. Top of the lordship, page 21. Principle 10, if the applications of eligible candidates remain pending and cannot be considered due to want of vacancies for a period of 2 years from the date of making such application will require no further consideration and must be understood to have spent their first lordship. Meaning thereby it is required to examine for 2 years.
Principal number?
Pencil number 10 lordship of page 21 of my writ petition lordship. That is the settled law lordship.
Did you consider again? Have you considered again?
That instruction, my lord. Right now, I have not that instruction, my lord. On the instruction leader, 26/9/2016, my lord, rejected,
That is there.
my lord.
You take some instruction,
My lord.
but Mr.
BK Gogoi lordship.
DK Google and consider Mr. P. Cycle and Governor. Set of instructions as to whether the case of the petitioner for appointment of commissioner ground was reconsidered. After the first DLC meeting held on 26/9/2016 was reconsidered again. After the first DLC that held this meeting on 26/9/2016. List after,
Then that's-
list after to,
Lordship, while it fix a date lordship.
it will come.
Lord, obliged lordship.
26 of supplementary list. Done.
In this case, my lord, the affidavit in opposition was filed and I have filed my rejoinder also. And my lord, otherwise the matter,
Affidavit in opposition.
yes, my lord.
Yes. You file your agenda.
Yes, my lord, I have filed my rejoinder. The very next day, my lord.
What is your case?
My lord, the case, my lord, is that the select list, my lord, for the admission to MBBS first year, my lord, the EWS category candidates who are qualified on merit, who are meritorious. My lord, they are known as any category, any student from the reserve category, my lord, who is meritorious, who is above the last general candidate. Let us call him MRC, my lord, meritorious reserve candidate. In this case, my lord, all the 60 candidates who have been accommodated, my lord, under the EWS, they are, my lord, more meritorious than the general category candidates as per the law, my lord, settled by the apex court, and also, my lord, as per their own rules of 2017, which I shall place before your lordship. My lord, the process is very clear. My lord. But I would like to place for your lordship's consideration, my lord, the rules of 2017. My lord. These rules were framed, my lord, in 1st of July 2017. These are, my lord, the medical colleges of Assam and Regional Dental College Guwahati, so and so, my lord, rules. If your lordship will kindly come to rule 8C, my lord, which is internal page, my lord, 2619.
Yeah.
My lord, rule 8 starts with this, my lord, so selection of candidates. My lord, we are not concerned with A or B, my lord, we are concerned with C here. After scrutiny and verification of the documents, if the candidate is found eligible, then selection board shall allot a seat to the candidate in the MBBS BDS courses in a college according to the choice of the candidate and subject to availability of the seat in that particular college at that point of time of his or her appearing before the selection board. Provided that in case of non-availability of seats in the college or course of his first choice, candidate shall be allotted seat in the college or course of his next order of preference, and so on. Well, the second proviso is very important. Provided that a reserved category candidate, as in 5A, B, C, D in the schedule 3 of these rules, entitled for selection on the basis of his or her merit position in the general or unreserved category, shall have the option of taking a seat in the college where a specified number of seats have been kept reserved for reserved category. But while computing the percentage of reservation, he or she shall be deemed to have been admitted as a general or unreserved category candidate and not as a reserved category candidate. You know, this rule,
What does it mean? What does
you know,
it mean?
this means very simple, you know, that let us say, my lord, that a candidate from the, let us forget EWS for a minute, let us say a candidate from the ST, my lord. He gets, my lord, he or she gets a marks of 600. And the last unreserved or general category candidate, my lord, scores 550, let us say, my lord. So in the order of merit, when the list will be prepared, my lord, the list is not prepared like you go on inserting reserve candidates like that. The list is always prepared, first of all, on the order of merit. So that ST candidate, my lord, or SC candidate, or whoever it is, my lord, from the reserve category, he or she will take his place in the order of merit on the basis of his marks. My lord, what happens is this, that the candidate takes his position at in order of merit, and thereafter, my lord, as per the order of preference, which they have filled up in their choice, my lord, at the time of filling up the forms for NEET, my lord, they indicate the institutional preference. Now, my lord, let us say that somebody chooses first preference as GMC, my lord, Guwahati Medical College. So Guwahati Medical College would have to have a reserved number of seats for that category. If ST, my lord, then ST category would have to be reserved there. And if in the order of merit, he is entitled to a seat under the ST category, then he will get into Guwahati Medical College. Because, my lord, what happens is that there are two parts of this rule. I will read out the second part. There are two deeming fictions here. What they have done is they have given effect to the first deeming fiction, but when it comes to the second deeming fiction, they are saying that there are other grounds we will come on, but they are not giving effect to the second part of the rule. What is happening here is that, as I said, my lord, if the ST candidate, let us say, for example, gets into Guwahati Medical College, then, my lord, a seat which he or she would otherwise have been entitled to. Let us say, my lord, that on the basis of her or his marks, he would not be getting Guwahati, but he would be getting, let us say, my lord, Dibrugarh Medical College. So then, my lord, what happens is that because of his reserved category status, he or she gets the Guwahati Medical College, but the seat in the Dibrugarh Medical College, for example, that seat has to go to the next in line reserved category candidate. What they have done is that instead of doing this, they have put in a general candidate in the next line. So on the basis of merit, otherwise reservation is meaningless. If somebody is getting on merits, then you do not have to pull anybody up. Because as we have shown, the last candidate under EWS has scored 568. Whereas the last candidate to have qualified under unreserved has got 552. Then what is the purpose of EWS? If all the EWS candidates are getting on merit, then there is no need of the EWS reservation because they are anyway going to get merit. The EWS quota is for those, my lord, who are below that general line. Because these candidates who are otherwise getting on the basis of their marks, their merit, my lord, they will be accommodated under the UR quota. They have done for some number of candidates, but they have not done for all the candidates. As a result of which, the cutoff for the last candidate of EWS has shot up to 568. This is an unheard of position. I was just as an aside, yesterday I was going through the cutoff for the Chhattisgarh, my lord, state quota. The general cutoff is somewhere near 536, last candidate on the general. The EWS is 473. So my lord, these candidates are below. That is why they are EWS. That is why, my lord, this beneficial provision of pulling them up. If they are already in order of merit there, then they are not required to be accommodated under the EWS quota. But at the time of the choice, what they are terming as institutional preference, yes, he or she will get the institution of his choice. And that institution has to have prefixed, pre-existing seats under the reserve category. As I said, if the candidate chooses first preference as GMC, so GMC has to have that reservation under the EWS or ST, SC, whatever quota. But when it comes to the next meritorious candidate, next in the sense that lesser meritorious candidate, let us say, my client, for instance, if he is pulled up in the list, he will not get the institution of his choice. He will be accommodated under the general quota. He doesn't have to be accommodated under the EWS quota. So there are two parts of the rule, and there are two dimming fictions. The candidate who is meritorious, coming from any reserve category, takes his place in the merit list, on the basis of his merit, but gets the institution of his choice on the basis of his reserve category status. So to that extent, they have, let us assume that the rules as they are valid. We have to assume because they have not been struck down. So, the rules, what do they say? That the meritorious candidate shall be counted against the unreserved quota. This is to maintain the 50% or whatever balance of reservation, because we cannot have all the entire reserve category cannot come into the general pool or something like that. So what has to happen is that candidate, the meritorious reserve category candidate, has to be accommodated under the general quota, but he gets institution of his choice. This solves the first part of the rule. So this means that the meritorious candidate, if he chooses GMC or Dibrugarh, so GMC or Dibrugarh has to have a reserve category seat to accommodate him. Otherwise, he will not get. Let us say, for the sake of example, let us say that the meritorious candidate is from Nagaon, where there are no reserve category seats under EWS. He says that, let us say, that Nagaon is my hometown. I don't like to go anywhere. I will choose Nagaon. He will not get it because there is no EWS seat in Nagaon Medical College. So he has to be accommodated in the next institution. Let us say GMC is below that. It never happens, nobody chooses Nagaon over GMC, but I am just taking an example. How they are interpreting the rules, if it is taken to its literal conclusion, what is happening? If he chooses Nagaon over GMC, he will not get Nagaon. He has to be accommodated under GMC because there is no seat in Nagaon. So there has the pre-existing reserve category seat has to be there in that medical college when the meritorious candidate chooses his seat. But this doesn't apply to the lesser meritorious candidates, the people who are back in the line, as my petitioner is. Now let us see what is the next part of the rule. That will solve the equation. It very clearly says, while computing the percentage of reservation, he or she here means the meritorious candidate, shall be deemed to have been admitted as a general or unreserved category candidate and not as a reserved category candidate. So his seat is not counted against the quota money. His seat is counted against the UR only. He is treated as an UR. Now, the second part. Under such circumstances, one seat of unreserved category of another college of his or her next preference shall be converted to the respective reserved category of that particular candidate to maintain the total number of reserved category seats. Now, what does it say? It says that one seat of unreserved category, which means one seat from the unreserved or general category, shall be treated to be a reserved seat. Now, again, going back to that example, let us say, that I was taking that if the candidate wants to take Nagaon, he or she will not get in Nagaon. But in Guwahati, he or she will get Dibrugarh and the other four, total 6 where there are EWS seats. But the Nagaon seat will be available, to the next lesser meritorious candidate, the next reserve candidate in the line, he or she cannot say that no, I also want the institution of my choice, because he is lower in the merit list. So he will not get that. He will get the general category seat, which will be deemed to have been a reserved category seat. This part of the rule says, my lord, that the general category seat will be treated as a reserved category seat. So there is no question of any pre-existing reservation. What they are saying is that because there are no seats in the other 6 medical colleges, so I can't accommodate so many EWS candidates. Absolutely wrong, my lord. Their own rule says this. There is no question of any pre-existing seat there. That pre-existing seat is from the general category. So whether it is Nagaon, whether it is Dhubri, Lakhimpur, Kokrajhar, all the new 6 other where there are no reservations, those seats will be counted as against, my lord, the reserved category, be it, my lord, EWS or any other category. So those candidates have to be accommodated like that. That is what their own rule says, and that is what the law settled by the apex court also says. What has been done in this case, my lord, that some EWS candidates have been accommodated under the UR category. Correctly so, my lord. First part of the rule says that.
Because of the merits.
Because of the merits. But there are other meritorious candidates, and they are saying that because of institutional preference, I am unable to give the others. I have given these people, I am not able to give the other seats because the other meritorious candidates, they have chosen a particular institution. But that is regardless, that if somebody is meritorious, he will get the institution of his choice, but provided that that institution has to have a reserved category seat. In this case, the EWS seat has to be there in that college. So in those 6 medical colleges, if there are seats for the EWS, then the meritorious candidates who are already there, who are already above the general line, those people have to be accommodated. But once they vacate the seat, then the next line, the next candidate becomes entitled to the general category seats. Let us say, going back to the Nagaon and Guwahati example, as I was saying, he or she chooses, let us say, Nagaon first, but he or she will not get it. He or she will get Guwahati or Dibrugarh or other colleges. So the next person in line, the person lower in rank, he or she will first get a chance in Nagaon. So one seat in that Nagaon medical colleges has to be treated as under the reserved category. This is irrespective of whether they have reserved 10% or not. Because here, they are not going as a reserved category candidate. Here, they will be going as a general category candidate because there are no seats in Nagaon or the other 5 medical colleges. So there are 2 parts of this rule. While they are giving effect to the first part, they are forgetting about the second part, or they are deliberately misinterpreting. It is no reason to say that there are a large number of EWS candidates, so I cannot accommodate everybody. It is what your own rule says. This rule has not been amended, and this rule has not come in a sudden. This is following the many judgments of the Supreme Court. I shall lay down 1 or 2 for your lordship's consideration. Specifically, this is the law that the candidate based on merit gets on the basis of his merit, but he gets the benefit of choosing his institution. And the candidate, the reserved category candidate who is next in line below him, he will get the seat which, in the general category which that candidate has vacated. So that is how the list is prepared. The list is not prepared like in a random manner, in an anomalous manner that they have prepared. They have first prepared apparently some categories, then you have inserted from somewhere. No, this is not done. The EWS reservation as of today in the state of Assam has become a farce. It has become meaningless because there is no requirement of EWS. Those EWS candidates who have qualified, who have got up to 568, they are getting anyway on the basis of their merit. But what about those who are below? That reservation is for them who are below. And they have to be accommodated against the general category seats. They have treated the general category as if it is a separate quota. But general category is not a quota. It is an open, unreserved by its very name. It is open to all. Supreme Court time and again has said that the entire list may contain reserved category candidates, whether it is ST, SC, OBC, or EWS now. Doesn't matter. If they are getting on merit, they will get on merit. But the general category cannot be treated as a sacrosanct that no, I have to accommodate a particular number of general category candidates. So I will deprive those who are from the EWS or any other reserve category who are below in the list. It is because of this interpretation, this thought process that has gone into their preparation of the list, that the cutoff for EWS, as I said many times, that it is higher than the general list. But that is not the purpose of EWS reservation. Now, my lord, this is 8C. Now, if your lordship will have. No, I would like to refer to. One judgment, my lord, that the apex court, which will make the law absolutely clear. 656. This is, my lord, 2018 2SCC, page 656. 656. So also, my lord, the case where there was the issue of reservation of seats, my lord, in medical colleges, my lord, both for MBBS and for PG, my lord. And the lordship will kindly come to para 8, my lord, page 662. Lordship 7. If I may read it. Often in a competitive examination held for the purpose of admission in technical and medical institutions, etc., some candidates belonging to reserved category or categories qualify for the higher ranking on the basis of their own merit and depending on their performance in the common entrance test are placed in the general merit list. Such class of candidates belonging to reserved categories who qualify on their own merit to be placed in general merit list are described for the purpose of convenience as meritorious reserved candidate, MRC. It is by now well settled that an MRC who goes on to occupy a general category seat is not counted against the quota reserved for a reserved category candidate, but is treated as an open competition candidate or general merit candidate. This court in Indrasani, the famous judgment, 9-judge bench, Indrasani. In this connection, it is well to remember that the reservations under Article 16, Subarticle 4 do not operate like a communal reservation. It may well happen that some members belonging to, say, scheduled castes get selected in the open competition field on the basis of their own merit. They will not be counted against the quota reserved for scheduled castes. They will be treated as open competition candidates. Para 9. Even in service matters, the same principle is made applicable. The aforementioned principle of Indrasani is followed for admissions to seats in medical colleges, and the same was followed in R.K. Sabharwal versus State of Punjab. However, the issue before us is more nuanced, whether MRC can opt for a seat earmarked for the reserved category. If answer is yes, then since MRC exercises the option of admissions to the seats in different colleges, earmarked for reserved category candidates, should a less meritorious reserved category candidate who is affected by such process be given admission to the college left over by MRC consequently. Next parameter. This would be better understood by a simplified example. Let it be assumed that there are 100 seats available through one common entrance examination to PG courses in various medical colleges across the country. Of these, 50 are general category seats and the remaining 50 are reserved category seats. X, a reserved category candidate, is assigned rank number 50 on account of his performance in the entrance examination. Thus, he is just above the cutoff for reserved category candidates and he has got an open merit rank. Hence, X is an MRC. However, X, being in the general category, is not willing to accept the seat available for general category at the time of his counseling. He wants admission in another college of his preference, which is incidentally reserved for reserved category candidates, and a seat in the same is available in the reserved category. Consequently, X chooses a seat available in the college meant for reserved category candidate based on his merit among the reserved category candidates. As he does so, one seat in the general category list of 50 candidates remains unoccupied. In that context, two questions arise for consideration: whether X MRC can opt for a seat earmarked for reserved category. 2, if the answer is yes, what happens to the 50th seat, which was to be allotted to X MRC, had he opted for a seat meant for the reserved category to which he belongs? This court has repeatedly, including the judgment in Indrasani, concluded that the aggregate reservation should not exceed 50%. Therefore, even when an MRC opts for a seat reserved for reserved category candidates, caution has to be exercised to maintain the reservation to 50%. So also, it is not open for the authorities to deny an MRC in a seat in the college of his preference based on his merit if such a seat is available at the relevant point of time, and the same is reserved for candidates of the reserved category to which the MRC belongs. I pause here for a minute, my lord. Twin requirements. One is that on merit, he should be entitled, reserved category candidate. Second is that there should be a pre-existing seat of the reserved category in that college. I took the example of Nagaon and Guwahati, my lord. Nagaon, there is no seat, so he will not get. But in Guwahati, my lord, a seat is reserved, so he will get it. This is the difference, my lord, what happens. Now, if I may read on, my lord. This is because there may be instances where an MRC may not get a seat in the institution of his choice on the basis of his own merit in the general merit. Under such circumstances, he may opt to be treated notionally as a candidate belonging to the reserved category only for the purpose of getting a seat in the college reserved for reserved category students. If such MRC is to be placed in the reserved merit list of his category, he would be ranking high and may get a better choice of institution or course. An MRC cannot be placed in a disadvantageous position by not permitting him to be treated as a reserved candidate, as that would amount to making him suffer for his better performance in the competitive examination. Next paragraph. In Ritesh R. Shah versus YL Yamul, this court has had an occasion to deal with both the above questions. This court held that an MRC who has opted for a seat in the college reserved for reserved category will not migrate or shift to the reserved category, but should be treated as a part of the general category only. However, only for the purpose of getting better choice of seat in the college, he may opt to take a seat in the college reserved for the reserved category. This court observed thus. In view of the legal position enunciated by this court in the aforesaid cases, the conclusion is irresistible that a student who is entitled to be admitted on the basis of merit, though belonging to a reserved category, cannot be considered to be admitted against seats reserved for reserved category. But at the same time, the provision should be so made that it will not work out to the disadvantage of such candidate, and he may not be placed at a more disadvantageous position than the other less meritorious reserved category candidates. Therefore, said objective can be achieved if, after finding out the candidates from amongst the reserved category who would otherwise come in the open merit list, and then asking their option for admission into the different colleges which have been kept reserved for reserved category, and thereafter the cases of less meritorious reserved category candidates should be considered, and they will be allotted seats in whichever colleges the seat should be available. Again, I pause, my lord. Whichever colleges the seats are available, the less meritorious reserved category candidates have to be accommodated there. No requirement of any, my lord, pre-existing reserved category seats. In other words, while a reserved category candidate entitled to admission on the basis of his merit will have the option of taking admission in the colleges where a specified number of seats have been kept reserved for reserved category, but while computing the percentage of reservation, he will be deemed to have been admitted as an open category candidate and not as a reserved category candidate. Next paragraph. And right from the year 1996, the law is well settled that the provisions should be so made that they will not work out to the disadvantage of an MRC, and he would not be placed at a more disadvantageous position than the less meritorious reserved category candidates. Aforementioned objective can be achieved if, after finding out the candidates from amongst the reserved category who would otherwise come in the open merit list, and then asking their option for admission into the different colleges which have been kept reserved for reserved category, the cases of less meritorious reserved category candidates are considered. In other words, the reserved category candidate is entitled to admission on the basis of his merit, and he will have the option of taking college admission to the colleges where a specified number of seats are kept reserved for the reserved category. However, while computing the percentage of reservation, you will be deemed to have been admitted as an open category candidate and not as a reserved category candidate. Then, my lords, your lordship too. My lords, para 23, page 670. Para 23. In the matter on hand, it is not the case that any other candidate of the reserved category other than the candidate taking up the MRC's general category place in choosing general category seat will be adjusted. Moreover, this issue is not under challenge in the present case, as both sides are admittedly not contesting the right of an MRC to choose a seat earmarked for the reserved category. On the other hand, it is fairly submitted by so that an MRC has got a right to choose a seat earmarked for reserved category or categories. However, they are only worried that the aggregate reservation should not exceed 50%. It follows from the cases cited above that the 50% reservation rule should not be breached under any circumstances. As mentioned supra, an MRC in medical admissions has more marks than the last general merit candidate. Hence, he shall be treated as a general category candidate. Only a choice of college seats in the reserved category is open to him. In this manner, the number of seats in each category remains constant, and the upper limit of 50% reservation is not breached. It is clear from Ritesh R. Shah that in the case of admission to postgraduate medical institutions, an MRC who chooses to avail of the option of admission to a college with seats kept for the reserve category is deemed to have been admitted as an open category candidate. He continues to be open category candidate. There is no migration into the reserve category, even if an MRC opts for a seat earmarked for reserve category candidates. The lowest ranking candidates who qualified in the reserve category cannot hence have option for colleges or seats in the reserve category on account of the MRC's choice may be adjusted against the choices of college seats then available in the general category left over by MRC. Well, they have to be adjusted in the general category. They do not have an option. They do not have any claim over reserve category seats. This is the ratio of this judgment. However, such reserve category candidates continue in the reserve category except for such option. Thus, by treating an MRC as a general category candidate, the number of reserved seats remains the same and reservations do not exceed 50%. This is also consistent with the principles of equity. In view of the above, we could not find any reason to disagree with the conclusions reached by the full bench of the High Court. In light of the cases discussed herein above, both questions are answered as follows. An MRC can opt for a seat earmarked for the reserve category so as not to disadvantage him against the less meritorious reserve category candidates. Such MRC shall be treated as part of the general category only. Due to the MRC's choice, one reserve category seat is occupied and one seat among the choices available to general category candidates remain unoccupied. Consequently, one lesser ranked reserve category candidate who had choices among the reserve category is affected as he does not get any choice anymore. To remedy the situation, that is to provide the affected candidate a remedy, the 50th seat which would have been allotted to ex-MRC had he not opted for a seat meant for the reserve category to which he belongs, shall now be filled up by that seat by that candidate in the reserve category list who stands to lose out by the choice of the MRC. This leaves the percentage of reservation at 50% undisturbed. We reiterate that 50% reservation rule should not be breached under any circumstance. So, my lord, this is the ratio of that this judgment, my lord. And there are several other judgments, but I would not, my lord, repeat. Look, the fact of the matter is, my lord, that in the reply, they have stated exactly whatever has been submitted in the court, that because of the lack of options in the 6 other colleges, lack of seats, rather in under the EWS category in the 6 other colleges, we could not accommodate the EWS candidates. But as we have shown, my lord, there is no requirement to keep any seat under the reserve category in a particular college in order to give effect to Rule 8C, as well as to give effect to what the apex court has said, right from Indra Sahni, my lord, right up to, my lord, the present times. The law has not changed, my lord. The reserve category candidate on merit, the MRC, let us say, my lord, he has to be treated as unreserved. Only he gets the, my lord, college of his or her choice. And whatever the seat that he leaves behind, that is the seat that he would have got had he not been from the reserve category. That seat would have to, my lord, be given to the next, my lord, in the line, reserve category candidate. So in this case, my lord, all the 60 candidates who have, my lord, accommodated under the EWS quota, all of them have got the institution of his or her choice. So the next, my lord, they have to be treated as open category candidate or unreserved. That is what the Supreme Court says. And that is what their own rule says. That being the position, my lord, that equal number of candidates who are below them, my lord, they have to be now accommodated against the general category seats in whichever colleges there is vacant. There is no requirement. What they are saying that there has to be pre-existing reserve category seat. No.
You are left with no other option.
I am left with no other option. I do not have any claim or any lien over the reserve category seats. That is what Rule 8C says. Rule 8C is absolutely clear. Rule 8C uses the word converted. General category seat converted to reserve category. But that is only what we know, Malab, as we say, Malab, deeming fiction. The first deeming fiction being that the MRC will get through on merit in the general list, but he will get the institution of his choice, but he continues to be treated as a general category candidate or under the unreserved quota. So the MRC remains under the general quota only, except for his choice. And the lower ranked, my lord, reserve category candidates, the second deeming fiction, notional as we may say, he rather gets a general category seat, which is treated or deemed to be a reserved category seat. So irrespective of whatever, my lord, whether there is reservation or not, these people have to be accommodated, my lord, under the EWS quota. Only the fact remains that they will come under the EWS quota, but they will not get the seats for the EWS choice. So they will not get the seats as the situation stands today in Guwahati or the other total 6 colleges. But they have to be accommodated against the general category seats in the other 6 colleges. So they have no choice. So subject to whatever my learned friend says, my right of rejoinder.
Manoj, so far as the judgment that has been cited, clearly covers our case. In fact, it is in our favor. Lordship may kindly have a look at the rule first.
Yes.
Again, Manoj. Rule 8C, the proviso. Provided that a reserved category candidate as in 5 so and so in the schedule 3 of these rules entitled for selection on the basis of his or her merit position in general unreserved category shall have the option of taking a seat in the college where a specified number of seats have been kept reserved for reserved category. But while computing the percentage of reservation, he or she shall be deemed to have been admitted as a general candidate. Also, this is important, my lord. Though he will be given a seat under EWS, but he will be considered as a general candidate, category candidate, and not as a reserved category candidate. Now, lordship, next line. Under such circumstances, one seat of unreserved category of another college of his or her preference shall be converted to the respective reserved category. But since, my lord, he is otherwise eligible for admission under the unreserved because of his higher rank, though he is an EWS, he prefers his choice of college. He cannot get it, my lord, if he is considered under the unreserved. So he may have a seat of his choice as a EWS candidate, my lord, but he will be considered a general candidate only on the strength of his merit position. And a seat, my lord, in the unreserved category will be now converted to again to a EWS seat, so that 50% is maintained. That's the rule, my lord. In fact, para 8 that has been, my lord, laid down by the Apex Court. My lord, because a particular candidate by dint of his own merit, if he gets a higher rank, his, my lord, there is no such law that, my lord, he's right for his, my lord, having a seat under the reserved category, say EWS, that is waived automatically because he has scored higher marks. That cannot be, my lord. He can always claim that I want to have a seat under the EWS. So in order to maintain that, he is granted he is considered as an unreserved category candidate, but, my lord, he is given the preference to have a seat which has been reserved for EWS. And moment he takes a seat under the EWS, though he is otherwise is considered as an unreserved category candidate, a seat under the unreserved category candidate is converted to EWS, so that the balance remains. That is the law, my lord. That is what has been, my lord, spelled out in para 8 of this, my lord, judgment.
So in the present case,
And, my lord, this discrepancy that the petitioner is pointing out of what they are feeling that they have been deprived illegally by this rule is because of the fact that, my lord, this year there is a counseling is going on for 12 colleges. And except, my lord, EWS, in all the unreserved reserved category candidates, quotas, my lord, he is there in all the 12. But in EWS, it is there only for 6 colleges. So they are, my lord, of this, my lord, they are feeling that, my lord, they have been deprived. It is limited to 6 colleges. Lordship will find in this, my lord, chart of in the merit list that, my lord, after, my lord, the EWS quota was completed, person below in rank who is otherwise a EWS candidate, my lord, he has been admitted in other 6 colleges as unreserved category candidate because that right always remains, my lord. A reserved category candidate.
let's see the list.
Yes. Lordship will find it starts from page 57. Lordship will see the first candidate on merit, my lord, in unreserved category. Serial number 1, he is a EWS, my lord. Then, my lord, Lordship will see serial number 13. He is a EWS. Because he has got his choice of college, my lord, Lordship will see, my lord, in the last column, selection details in the right hand side, my lord. Here, Lordship will see code number means the college code. And, my lord, the category is there, quota, unreserved, 13 unreserved. serial number 1 unreserved. Their my lord preference of college was GMC, so they took it as unreserved. In the next page, lordship, 58, serial number 29, 30, 31, 32, all are EWS. 35, 36, and 42. All have been granted their seats as unreserved because they have got their choice of college, so they don't want to exercise their reserved category quota. Then lordship will turn to next page. 59, page 59. Here, my lord, serial number 50, 51, 52, 54, 55, 58, 60, 63, 64. All under my lord, unreserved category because they've got their choice of college, that is GMC. Now, my lord, in next page, it will start, my lord. Lordship will kindly see. Say page 60, serial number 68. Here is a SC candidate. Considering his rank, my lord, he has been considered as a unreserved candidate, but because of the category, the quota he is holding, lordship will see, my lord, in the quota, my lord, it has been mentioned that SC has been converted to unreserved. 101 means the Assam Medical College has been converted to SC. So this conversion has been made as per the rule C.
So 102.
101. Serial, my lord, 68. But the code of the college is, my lord, in case of Assam Medical College, it is, my lord, 102. For GMC, it is 101.
Yeah, here it is 102, 68.
Serial 68. No, it's 101. No, Kunal Das. I'm talking about Kunal Das.
No. This code is 102.
No, 101.
Check it out.
No. Lordship will see quota. In the quota,
Quota 101.
101. Unreserved. So, Lordship is, my lord, may I read, my lord, the last part of the rule again. Under such circumstances, one seat of unreserved category of another college of his or her preference shall be converted to the respective reserved category of that particular college. So his preference was medical GMC. So in AMC, the post has been converted to, or seat has been converted to EWS. 101 code is for AMC, Assam Medical College, Dibrugarh. It says, my lord, rule says, under such circumstances, one seat of unreserved category of another college, not in that college, where he has been given under EWS, another college of his or her next preference. So, my lord, the first preference of this particular candidate at serial number 68 was GMC. Second was Assam Medical College. So now, my lord, since otherwise by, my lord, by the strength of this rank, my lord, he was not otherwise entitled for the seat in GMC. But he has exercised this, my lord, quota, and he was granted seat in GMC. But his next preference was, my lord, Assam Medical College. So one seat in, my lord, Assam Medical College of the unreserved category was converted to EWS, to SC in the present case, 68. Same way, lordship will find at 73. 73, Mustaq Ahmed, EWS. So EWS, he got the seat, my lord, in GMC under EWS, so it has been converted to unreserved. He will be considered as an unreserved candidate, not as an EWS candidate. And, my lord, the unreserved seat in 101, that is AMC, will be converted to EWS. So that, my lord, the quota is maintained, my lord. As per the rule, in fact, my lord, para 8 of the judgment says so, that candidate will be considered as a general candidate or unreserved candidate, even though he, because of his choice of preference of a particular college, he takes a seat under the reserved category. But it will have to be converted, and that candidate will, in the merit list, will be considered as a general unreserved candidate. That we are doing, my lord. And, my lord, in the present case, why, my lord, one statement has been made that, my lord, some, my lord, EWS candidate who are in lower in rank, at the bottom, my lord, they have been granted seat under the reserved category, unreserved category. The reason is, my lord, this time only in 6 colleges the EWS, my lord, quota has been granted, which is under challenge before his honorable lordship is taking up those matters. So here, my lord, the unreserved category, the EWS category, that is 69 in numbers. were filled up with the higher meritorious candidates because though they were under the unreserved category because of their rank, they choose to have a seat, my lord, in the choice of college under the EWS, and those were converted. And the EWS candidate who are in below in rank, on the basis of their merit, they have been granted as an unreserved category candidate, which everybody can always, my lord, have that preference. And they have been given the seats. Only because of these 6 colleges, this, my lord, discrepancy has arisen. Not a discrepancy, they are thinking it to be a discrepancy, but it's not a discrepancy. Had there been, my lord, EWS category candidates in all the 12, my lord, colleges, these, my lord, issue would not have arisen.
What happened to the other case?
Other case is pending, my lord. Lordship has fixed it up on 9th of September for final disclosure. And one, my lord, another case has been filed where my friend is appearing on behalf of the petitioner. That is fixed tomorrow, where the rule has been challenged. It is before the division bench. So it is coming up tomorrow for probably. final disclosure.
For the present case, my lord.
Yes,
let
for
us
the
assume
present
that
case, my
the
lord,
rules are
the
valid. We are
rules are valid.
presuming rules are valid.
And my lord,
It is
as
the
per
question
the
of
law letter
interpretation
by
of
the
that.
apex code in
That's
para 8 of the judgment, just now my learned friend has placed. We are doing that only, my lord. Nobody has been, my lord, deprived. And my lord, the balance of 50% for unreserved, 50% for reserved, that has been maintained. There is not a single candidate above, my lord, 69. 69 seats has been reserved for EWS. Exactly 69 has been given. Only thing is that, my lord, the higher meritorious EWS candidate, they, my lord, opted for this, though they were in the unreserved category list, for my lord, getting a, my lord, preferential college of their choice. And my lord, the EWS seats where they have occupied were converted to general category seats. That is the issue, my lord. No irregularity at all, my lord. And this particular, my lord, formula or procedure that is prescribed in 8C, if they are aggrieved by this, they will have to challenge it, my lord. If they are not aggrieved by this, then, my lord, we are following in toto. Otherwise, my lord, we have explained it in our affidavit. One affidavit we have filed. Para 4, relevant will be, my lord, para 10. May I read it, sir?
Yes.
The deponent makes to state that the counseling for the provisional selection of candidates for admission in the MBBS BDS course of Government Medical and Dental College of Assam respectively was conducted by online method under the direction of National Medical Commission and as per Medical Colleges and Dental College of Assam Regulation of Admission into First Year MBBS BDS course Rules 2017 amended up to 2003. As per the above rules amended up to so reservation of seats for different categories were defined for state quota after deduction of seats reserved for non-residential Indian, non-resident Indian sponsored candidates. Accordingly, a seat matrix was prepared and published in the official website, which in brief is as follows. Well, total MBBS seats in the 12 medical colleges 1,500 in the state of Assam. The total state quota seats after deducting 15% All India quota seats, Central Pool seats, NEC seats, Royal Government of Bhutan, for the state of Assam, it remains is, my lord, 1254. Now, NRI, this year, my lord, it has been introduced in the state of Assam. 88 seats goes to NRI. Now, total state quota seats remains is 1166. Now, for unreserved out of 116 is 525. Lords, you will see, my lord, from the list I can demonstrate, my lord, exactly 525 candidates have been granted admission under the unreserved category. So the balance has been maintained. Now, Lords, you will see at the bottom, my lord, EWS 69. Now, BTS seats is not issue here. Next page, my lord. The deponent for the begs to submit that as per the above mentioned rules, EWS seats were available in 6 medical colleges only. Assam Medical College, Dibrugarh, Guwahati Medical College, Guwahati, Silchar Medical College, Silchar, Jorhat Medical College, Jorhat, Borpeta Medical College, FAA Medical College, Borpeta, and Tezpur Medical College, Tezpur. Further, the deponent begs to submit that institutional preference is given priority while allotment of seats is made to a candidate. In case of allotment of seats to EWS category candidates, this was limited to 6 medical colleges only, as mentioned above, while it is available in all 12 medical colleges for other category of candidates. Well, this is important. Kindly mark this. The deponent begs to state that during the first round of counseling for 2023 session state quota seats, it has been seen that EWS category candidates who took part in the counseling process opted their preference in favor of these 6 medical colleges where EWS seats are available, and gave preference for remaining six colleges after these 6 medical colleges. There is Assam Medical College, Dibrugarh, GMC Guwahati, SMC Silchar, JMC Jorhat, FAMC Borpeta, and TMC Tezpur. This has resulted in EWS candidates with higher merit getting allotment in these 6 medical colleges under EWS category seats who otherwise is eligible for a seat in the unreserved category by way of conversion of seats. This provision for institutional preference and conversion of seats by the unreserved category is prescribed in Rule 8C of the Admission Rules 2017. However, EWS candidates who could not get the EWS category seats after the last EWS category seats were allotted to in the 6 medical colleges under unreserved category where EWS seats are not available in terms of the amended rules 2023. In this way, all EWS candidates who took part in the counseling process were given opportunities as per their preference without any prejudice, be it under the unreserved seat or under the EWS quota, as per their merits and the prevalent rules. The deponent begs to state that this has not happened in allotment of seats for other category of seats were available in all. Now, this has available in all 12 medical colleges. Had it been that EWS seats were available in all 12 medical colleges of the state, allotment would have been as any other category. Explanation, my lord. Total seats of for EWS category is 69. Total seats allotted to EWS category students is 69. Last candidate who was allotted EWS seat is rank. Lordship may kindly mark the rank 50245.
Is 69 countries including it includes unreserved?
No, it's for EWS.
Only EWS.
Yes,
Not
10%.
not the EWS who are under the unreserved.
No, it was converted. Moment they
Seats
yes,
will be
seats
converted.
remain same. That's why you have stated, my lord, total seats allotted in EWS category student is 69. It has been maintained. Now, lordship will see we have given my lord the details of the last candidate who has been admitted under the EWS category candidate. His rank is 50245. Now his choice of college was GMC first, Assam Medical College, Dibrugarh second, Jorhat Medical College, Jorhat, Tezpur Medical College, Tezpur, and Nagaon Medical College, Nagaon. 6 is my lord Dhubri Medical College. So my lord, till Tezpur, these 4 colleges come within the 6 my lord colleges where EWS quota seat is available. So at the time of counseling, it was like 5024. Yes, lordship may kindly turn to the next page. Why, how he has been given is explained, my lord, page 204. The deponent further begs to state that since the last EWS seats was available at Tezpur Medical College, Tezpur, and the candidate belonging to EWS category, this seat was allotted to her. Preference 4. That is, my lord, this my lord candidate, Jhalak Jalan. If she would have been allotted under unreserved category, she must have been allotted unreserved seat at Nagaon Medical College, Nagaon. Preference 5. We should have gone against the policy of giving institutional preference. So it has been explained, madam. Because of her choice of college, which was available only in Tezpur Medical College under the EWS quota, she was allotted in Tezpur Medical College. But the EWS seat was converted to the general category seat was converted to EWS in the next college. It will be within these 6. Further, the last EWS category candidate who was allotted MBBS seat under unreserved categories, Rosmi Shukla. Now, lordship will see her rank, my lord. It is 62358. She is below this, my lord, last candidate who was admitted under EWS. But she has been considering her rank as an unreserved category candidate. And she has been allotted a seat in considering the entire 12 colleges. And the lead petitioners are even below this particular rank, 62358. So, my lord, to say that, my lord, they are otherwise deprived, it's not them, it's not the my lord case yet. So this is, my lord, my humble submission, my lord, so far as the present case is concerned. In fact, the law laid down by the Honorable Apex Court, which has been, my lord, reiterated in, my lord, 2018 case, has been duly followed. And if required, my lord, I can furnish the list before this Honorable Court, segregating, my lord, EWS and the unreserved category from this particular list that has been annexed in the petition. Page number given, 400.
Yes, you can produce the list.
It will be more convenient in that case, my lord. 525, my lord, other.
You reserve your reply letter.
Lodge.
525 for unreserved and 69 for EWS. Then everything will be clear. Because here, my lord, the entire compilation contains, my lord, all the unreserved and reserved category candidates. That is 1166 candidates.
But A. Ganguly, Learned Council. Mr. B. Gogoi, Learned Standing Council, Health.
Help.
Health Department shall produce a list of the
Reserved and unreserved and EWS category candidates
list
who
of
have been
the
admitted
of
or an
the
allotted.
of the unreserved and EWS candidates who have been admitted into different medical colleges in the state of Assam.
Lord,
When
my lord, next week, my lord, any day convenient.
any date
Lord,
convenient.
the only difficulty is that the classes will start from first. Clarity, my lord, before that. That is the difficulty. Today we are on 24th. Let them come. They can produce on Monday also, my lord. They are the department. They have the list. There's no difficulty. And I have no need to respond to that list. My lord. That list is for your lordship's convenience. So, my lord, that they can produce it on Monday. We can have it on Tuesday, perhaps.
29th, my lord. Tuesday.
Engineering.
Notify appear for the National Medical Committee.
Mr. T.K. Bhatia, Council, Standing Council,
NMC.
NMC appears for the response number
3, my lord.
27.
My lord, kindly pass over the matter for the time being, my lord. Engage senior counsel, court number 1, my lord.
1 minute. We do one thing. Get a copy of this. That's why I put it to the court. Put it on the board.
Yes, my lord, engage senior counsel is Lakes and court number 1, my lord. Kindly pass over the matter for the time.
Item number
27, my lord. My lord, yesterday, my lord has heard the matter. For the time being, my lord. Oblige.
28. Vacating application.
One 129.
No, she will be pleased to take up 2052. The application for vacating.
Where's your objection, Mr. Shi?
What?
IA 1829. Flag A. IA
1829.
Oh.
Your lordship will find flag A.
Is it affidavit in reply?
My lord.
No, 1829 is 1829 is for what?
Could have even then I wanted to.
Yes. 1829, my lord, that application I filed to maintain the status of the petitioner.
Oh,
Thus against that,
that
my lord,
is filed by you.
my lord. And against that, they have filed an application to vacate the stay order passed by this honorable court.
Yes. So against this order was passed in this IA?
Yes, my lord, 1829.
What order was passed?
That, my lord, your lordship will find.
Oh, 23/6/2023.
Yes, 23/6/2023,
Where it was suspended,
my lord.
19/6/2023. Okay, then he has filed this IA for vacating.
For
the
vacating,
chamber.
my lord.
Now, in this IA, you said that you have filed your objection.
That objection we have filed.
Where is that objection?
That is, my lord, IA 1829 flag A.
No, that is a reply.
Yes. Reply to the stay vacating application.
Oh,
If your lordship see the cause title of IA 1829, an affidavit in reply for and on behalf of the writ petitioner to the application praying for vacation, cancellation of the order dated 23/6/2023.
yes. So actually, this flag case should have come in the other one.
Exactly, exactly. That's the confusion created, man.
Yes. Two zero five.
Lordship has just noted the order that was passed by your lordship on 23/6/23 at page 22.
Okay, IA.
Yes.
Yes.
Your lordship, by this, this honorable court passed the stay order whereby the writ petitioner sought to continue as the vice principal of the school. What I would submit is that the writ petitioner right from the very beginning in 1994 has been continuing as an ad hoc employee. She's been appointed every 6 months and he has always admitted that she will not claim regularization. The appointment was limited to 6 months everything. At this particular school is a school established by the Brahmaputra Valley Fertilizer Corporation Limited, earlier Hindustan Fertilizer Corporation. And the school was started for the purpose of accommodating the children of the employees of the fertilizer unit. In course of time, the neighborhood children also started coming to the school. But the policy of the company was not to have any regular teachers there, except for two, the principal and vice principal. And they were chosen normally from within the employees, regular employees of the corporation. All the others were ad hoc. What has happened was recently,
Now, how do you choose from the regular employees when the others are all ad hoc?
no, it's a policy. We had only two posts, principal and vice principal.
That is regular post.
Yes.
The rest of the other teachers are all ad hoc.
all ad hoc.
Now, how do you choose the principal and the vice principal?
From the regular employees or from outside?
From outside the college?
Outside the school.
Outside the school.
Yes. Depending upon eligibility. Now, as far as the corporation was concerned, they chose these two employees from regular employees from the corporation who were interested in looking after the school, be appointed as principal and vice principal. We didn't have, after the retirement of the previous principal, that question arose as to how to fill up post of principal again. So an advertisement was again given. An employee, regular employee of the corporation only applied and was chosen. And he joined your lordship on the dates when your lordship passed the interim order. But the petitioner, in spite of being ad hoc, she refused to give up the post. She kept on continuing, requesting the regular principal to give her some time. And that was where the problem arose. And she's come before this honorable court and obtained a stay. And is without making the regular vice principal as the party. The anomalous situation, meantime, her ad hoc appointment term also expired. He is now attending the school without any function.
Without
Any functions. Possibly attending, because we have not extended it because she has not sought for it. And the grievance was that meantime we took out a policy whereby we said we'll appoint all these teachers as employees through an agency by outsourcing. And those ad hoc employees, they've been given much better benefits as teachers in the school now. The petitioner has not accepted. He's challenging that also, which is that it is not maintainable on that ground also. The two challenges, one is a case for regularization, and the other is for challenging the tender document whereby an agency was appointed to engage the ad hoc employees. Now, your lordship will please look at the advertisement at page 28. This was a departmental advertisement for filling out the post of vice principal in the corporation at Namru. For day-to-day administration routine works in BVFCL higher secondary school, Namru is required. Further, it is to mention that as on date, no regular employee is posted in the school. In view of the above, as per NPC, the manpower position as on 1/5/23 are as under. Men in position, grade E3 and E2 Euroshed, the principal and vice principal alone.
both deemed to be senior teachers. Amongst the 28 number of contractual employees. All the other teachers were contractual, ad hoc employees.
This is not an advertisement.
No, the next page is the advertisement. The proposal was put up on 26/5/23, and on 27/5/23, the departmental advertisement was published. Based on this advertisement, the selection committee was set up, and they considered the case of the respondent number community.
So the writ petitioner applied for the post.
No. Didn't. He continued to remain ad hoc.
Ad hoc teacher.
She has no right whatsoever to continue as such. We allowed her exigencies of service, stopgap arrangement when the principal, vice principal were not there in the school. Her appointment all through was ad hoc. The Lordship will be pleased to see the office order by which the petitioner was allowed to take the responsibility of vice principal for a limited period. That is at annexure 3 of the IA 2052. Your Lordship has that. Page 24 at annexure 3.
20.
It's 24.
Yes.
It's an order dated 31/10/22, whereby for administrative convenience, Mrs. Bornali Chetia, ad hoc teacher. She's a petitioner, ad hoc teacher come demonstrator of BVF HS school, has been entrusted the responsibility of vice principal. He is also hereby authorized to sign all the documents as vice principal, BVFC school, in respect of academic sphere, such as conducting examinations and announcing results, etc., and to operate the school bank account till further orders. In the event of any problem in respect of administrative matters as well as in academic sphere, he will report to the senior manager, administration of the corporation. Other terms and conditions of her present appointment will, however, remain unchanged. He continues as ad hoc teacher. That is the main post. And on the next page, on 7/12/22, and issue 4. For administrative convenience, Mrs. Bonali Chetia, ad hoc teacher cum demonstrator, is hereby authorized to sign all documents as principal in charge BVFC school pertaining to the academic matters and operating of school bank account till further orders. All the functions were spelled out. Other terms and conditions of appointment will however remain unchanged.
So from vice principal, she was allowed.
No, she was, because we didn't have the principal and vice principal. That's why for purpose of handling the accounts, she was given charge also of principal. For limited period and limited purpose. Other terms and conditions remain the same. Ad hoc teacher.
Then
Your Lordship will see from the very initial appointment letter, which still stands to be continued in that form, is at NHF 5 at page 26. One. You are hereby engaged as teacher cum demonstrator, biology on ad hoc basis in consolidated pay for a period of 6 months on the following terms and conditions. You will be paid a consolidated pay of 16,550 only per month. No other allowances will be admissible. Your services will be purely on ad hoc basis for a period of 6 months only, with effect from 9/1/23. You will have no right to claim for regularization or absorption in regular vacancies of the corporation. Your Lordship. He has duly accepted these terms. Your Lordship will see the next page. Page 27. The joining report given on 27/2/23, with reference to the subjects cited above, I would like to inform you that I have joined as teacher cum demonstrator in BBSS School Namrup on ad hoc basis for a period of 6 months, accepting all terms and conditions on 9/1/23. This is evident from this only that she has no right to claim regularization on basis of the. And now she's come and obtain the interim order.
let us see the order that has been stayed by the school. One is 21/6/2023, correct?
23/6. That's page 22.
Page
22.
Yes. Who is this order 19/6/2023?
19/6. And it's order to the condition. At NHO 1, Your Lordship. Page 18. Consequent upon selection through departmental interview cum assessment, the following employee is hereby transferred to Higher Secondary School BBSCL Namrup with immediate effect. Shri Dhruvajyoti Charingya, Assistant Manager Instrumentation, is hereby transferred from Instrumentation Department to BBSCL Higher Secondary School Department with immediate effect. Now he will be designated as Vice Principal Henceforth, he will be directly reporting to senior manager. And so on. He's a regular employee. He's been now implemented as a party respondent. Earlier, he was not implemented.
Doctor, if I dispose of this, I'll be disposing of your petition.
My lord, I have filed our counter to this.
Would I not be touching on your merits?
My lord, I'll satisfy your lordships. Your lordship is required to leave the veil here. What has in fact happened,
No, that's why.
my lord,
If I consider this application,
my lord.
would I not be touching on the merits of the writ petition?
My lord,
It would
of
have
course,
it would have an effect on the merits.
my lord, that's the reason what I would like to say. Your lordship hear the entire matter.
Yes, this better.
Yes, okay.
Otherwise, your lordship kindly see, my learned senior friend has saying, her service period is 6 months, then after 6 months, there will be break. My lord, here, in this case, the petitioner has almost completed nearly 30 years. Now, can anybody say, can the management say that you have continued for 30 years and come to the court and say that, well, we cannot regularize? My lord, what the Nihal Singh case is, my lord, despite what Madhavi has said, Nihal Singh has said that the Madhavi's case cannot be licensed to that. Because if there is an irregularity, illegality in that case, only Madhavi will spring in, otherwise not. Now, here in this case, your lordship will find the person who has been brought here. Now, he is from instrumental department. Your lordship has seen the advertisement. Qualification was the requirement is not there. Now, the earlier time, my lord, they have said what is the qualification is required. Now, here now, just to ask me from there, the backlash is that because I have come before the court, I have taken an order, and the first order was what, my lord? Now, they want to put our services in the hands of a contractor. My lord, the apex court has deprecated that process because the teachers cannot be construed to be skill level. Now, they wanted to do that. We came before your lordships, my lord, the apex court has clarified that they are the noble teachers of the noble, they are in the noble profession. They cannot be treated as a, my lord, skill level. In 1988, apex court has said. Now, since we have come here, I filed a representation, being a principal of the college, that you cannot do it, there is an illegality. They got agreed by that letter. After that, they have started the process of this advertisement. And as your lordship has seen, he is the person who has come. There is no competition. My lord, the interview is a sham interview. In this case, my lord, I will request your lordship to call for the interview record also. That will, my lord, clarify that whether there was any interview or not. It is just to ask me, the process is there.
We produce, we annexed the proceedings. That is it.
In the writ petition also, you filed your affidavit,
Yes, yes,
counter.
yes.
So therefore, my lord, the entire matter can be heard because there are so many things, my lord, it will take time. So I think better to dispose of the entire case.
Yes. Instead of considering piecemeal.
Well, exactly,
I-
my lord.
Why not we go for disposal of the writ?
We want a disposal of the petition because this petition is not maintainable.
My lord, what is the reason? Because we have said the regularization as well as to saying that the process of giving the services to the hand of the contractor. Look, is there any law that the two conditions cannot be adjudicated by the court? I don't think, my lord. So therefore, these are all unnecessary things. Your lordship take up the entire matter in a one go, let the entire matter be adjudicated.
That is better.
Yes, my lord.
Let the matter be heard, but again, the stay order may be vacated for simple reason. You're on a date when this order was passed.
No, no, if I stay there. If
Which
I
is-
vacate
she's no
the
longer-
stay order at this stage. This is what I've been telling Mr. Datta also. I would be entering into the merits of the writ petition.
Yes.
It would prejudice the petitioner.
Right.
So therefore, what I'm saying is, instead of considering your IA today. Why not we go for final disposal of the writ petition?
We have no objection as long as it is done as early as possible,
Ah, there's no issue on that.
because she's not continuing now.
She must be continuing, there's
No.
already an interim order passed by.
My lord, how
You know,
this
the-
submission can be made?
Her term of 6 months is over.
My lord, this honorable court has protected us. If they want to say that, they will be facing contempt proceeding.
If it is content, then face contempt.
My lord, after 30 years of service, they want to say that I have agreed to all that. My lord, you have pressurized me that there are so many appeals court decisions, my lord, I will take your lordship.
30, 40 years.
Lord,
Your lordship.
Being a, my lord,
Supreme Court has not interfered.
if you are an authority, you are likely to work in a plausible manner, not in an arbitrary manner. That is the appeals court has time and again have been asking for. So therefore, my lord, if you exploit me for a decades and come to the court, say that she has been working for 6 months, then there is a break. Then again, after 6 months, he will continuing for long 30 years. Can it be the law?
Yeah, you take that. Third, Mr.
MZ Ahmed.
MZ,
Ahmed.
and it's Senior Counsel, assisted by. AM. AM. Good afternoon. Also heard Mr. Datta, assisted by Mr.
Yes, sir.
S. Datta. Then it's counsel for the applicant partner of the. After hearing the parties. This court is also considering. Instead of considering the present IA. It will be in the interest of justice to dispose of the amendment. And that we have. We solve these matters. Along with the writ petition. When do you want? Early date?
Any date, my lord, convenient to your lord.
Can
If
it,
you're convenient date, I'm always here.
Yes.
can it be 7th September? In the Thursday.
Seventh will be difficult. 12th September? Is it Tuesday?
12 is okay. सकाले किस लिए लेना?
14.
ठीक है. No problem.
14th.
Look, in the meantime, if it is needed to file any affidavit and all that, that can be done.
Yeah, in the meantime, parties are directed to exchange their affidavits in the main.
Further effect. We've already filed, but even
No, if it is required, it may not be necessary, but when the interim order passed, that may continue.
Interim order pass in the main.
Obliged.
we have also.
Who do?
27.
May it please, my lord. The concern of other part, my lord, kindly taken on Monday, my lord.
Item?
22nd, my lord.
My lord had heard the matter yesterday. Mr. Saike has some problems, my lord, today. PJ
He is
second.
here, my
My
lord.
lord,
but my
let it
lord-
be on Monday, my lord. The order, my lord, will continue till Monday. There is an interim. order.
On request, I was, we have also to cycle and it's. This the matter, you know.
Tuesday, Tuesday, my lord.
Tuesday, you are.
Tuesday. My lord can hear them
Interim order pass.
till Tuesday. Much.
Obliged.
Free of daily list, admission.
Lordship, due to some medical urgency, learned counsel has left the court. Kindly urgent, adjourn the matter.
Who's your counsel?
I think JC Gogoi, my
JC
lord, he has informed, my lord. There's
JC
some
Gogoi.
medical urgency is record of his child. He was there, my lord.
On request made on behalf of Mr. J.C. Gogoi, learned counsel. Please the matter after 1 week, 2 weeks,
Next week. Next week.
after 1 week.
Okay.
4, 5 and 6.
My lord, in this case, Lordship, I want file my rejoinder, Lordship, ready, Lordship, next week, any day, Lordship, subject to convenience. 31, Lordship.
Oh, see, Mr. K. Majumdar, learned counsel for the petitioner, press for a week's time
Lordship.
to file rejoinder to the counter filed by the
Respondent number 1, Lordship.
respond number 1. Praise the Lord. This the matter after 1 week.
Lordship, it may be on 31st, Lordship, fixed date maybe. Or
31st, I have got some difficulty.
then Lordship,
On 12th. 12th. 12th.
Seven.
Lordship may kindly fix this, because after 2 weeks, Lordship, I need to prepare the written argument, Lordship. And Lordship, I could not prepare the citation, Lordship.
Lordship, I have
In
strong,
the second week of September, I have.
strong objection to the time. It has been time and again.
Otherwise, Lordship, the
adjournment
case is ready for. If your Lordship.
He is holding the post of principal, he's enjoying it from a very long time. It's been 2 years now.
No adjournment. No adjournment on the next date.
Yes, yes.
Lordship may kindly
I'm
record.
already ready, Lordship, but, and your Lordship will take up for final,
He take a Lordship.
Learned counsel for the-
and final disposal in the admission stage or in the hearing, Lordship.
In the admission.
On request made by Mr.
SK Das.
H.K. Das, then counsel for the respond number 6,
7.
7. When do you want?
7th.
On 12th, Lordship, 12th September. 12th, final disposal.
On 12th of September. This made clear, there should be no adjournment on the next day.
Yes.
Mr. A. Das, then counsel appears for respond number.
Eight. Eight.
Done appears for the petitioner. You're done?
I'm for respondent, my lord. Petitioner.
None appears for the petition. Mr. S. Das, then standing counsel,
Higher division.
higher division appears for respond number.
And my lord,
Okay, let the standing counsel appears for the higher education department. And MS, K. Babujari, Leonard counsel, standing counsel appears for the UGC. Stop. When do you want? List after 2 weeks, 1 week?
Yes, 2 weeks. 2 weeks.
2 weeks.
Time for 3 and 6.
Mr.
M. Dr. Omar.
Appears for 3 and 6.
9.
Make please, your Lordship.
In after some time, then.
Why?
Mr. B. Kosing is handling this case.
Huh?
He's on lakes, my lord.
Week or shift?
Yes. ma'am. So matter may be taken after some.
Or at 2, Lordship.
No, we'll see.
Lordship. Because earlier also they have taken time, Lordship. My part already. over the Lordship.
10 and 11.
My lord, the matter may be passed over for the time being, my lord. My lord, Youngest counsel, Mr. A.K. Borua is on legs in another court, my lord.
I mean,
Oh, my lord, he's.
Meet Mr. Lordship. My lord, I'll just place the facts, my lord. Otherwise, pleadings are complete. On my lord, 7/9/2022, my lord, at around 4:20 PM, the petitioner number 2, who is a 7/9/2022, my lord. I've stated that at paragraph 6, my lord. Paragraph 4, my lord, page number 6, my lord. Paragraph 4, my lord. That on 7/9/2022, at around 4:20 PM, a classmate of the petitioner number 2, who was a 12-year-old minor, my lord, requested her to accompany her to the washroom during the games period. Accordingly, the petitioner number 2 accompanied her classmate, the so-and-so, my lord, to the washroom. On the way to the washroom, the petitioner number 2 stopped near the water filter to drink water. Thereafter, she found that another student, that is Master so-and-so, started engaging in a conversation with the other classmate near the washroom. Notwithstanding such conversation, my lord, the petitioner number 2 rejoined her other classmates and resumed her playing activities. Now, this was objected to by the school authorities. And what they did, on the very next day, my lord, they made us write some self-incriminating statements against our own self. On 17/9, the parents visited the school, my lord. They were warned on 17/9, my lord, 2022. If your lordship kindly turns to page number 8, my lord, I've stated that in paragraph 10. Paragraph 10, my lord. On 17/9/2002, my lord, 22, the parents of the petitioner number 2 went to the school to inquire about the matter. However, her parents were very rudely behaved. And my lord, the next line, be it categorically stated herein at this stage that the school authorities had also sternly warned the guardians. Page number 9, my lord, the first 3 lines, that if they do not apply for the transfer certificate from the school will themselves issue a transfer certificate to them containing adverse remarks against the petitioner number 2, which could finish her career. We submitted representations, my lord. Thereafter, my lord, on 23/9/2022, the petitioner number 2 was forcibly issued a transfer certificate, which your lordship will find at page number 39. If your lordship kindly turns to page number 39, my lord, this is the transfer certificate which was issued to them forcibly, my lord. If your lordship sees the serial number 18, name of the pupil is Deepika Sinha, serial number 1, and serial number 18, your lordship sees, my lord.
This is a petition number 2.
Petitioner number 2, because she's a minor, she is represented by her mother because she cannot sign the papers. So petitioner number 2, my lord, name of the pupil, and serial number 18, my lord, general conduct satisfactory, and serial number 20, date of issue of certificate is 23/9/2022, and the reason for leaving the school is parents' request. So we were forcibly issued a transfer certificate. We approached this honorable court, and this is what this honorable court had to say. My lord, honorable court's order, learned single judge, it starts at page number 40, my lord. Page number 40. I will not trouble your lordship with the entire judgment. I'll only point out the relevant paragraphs. Page number 45, the relevant paragraph. Paragraph 2. These are all undisputed facts, my lord. Paragraph 2, page number 45, my lord. It says, brief facts of the case as projected by the petitioners may be noticed at the outset. In WPC, my lord, 6695, there were three petitioners, my lord, 3 pupils. In WPC number 6695 of 2022, the petitioner number 2 is a 14-year-old minor who was studying in class 9 in Sainik School, Gwalpara, and the petitioner number 1 is his mother. In WPC number 6696 of 2022, the petitioner number 2 is the 12-year-old, this is the present petitioner, is a 12-year-old girl who was studying in class 7 in the same school, and the petitioner number 1 is her mother. Likewise, in WPC number 6698 of 2022, the petitioner number 2 is a 13-year-old girl who was studying in class 7 in the same school, and the petitioner number 1 is her father. The Sainik Skill Gwalpara is a co-educational school and it has got students from class 1 to class 12. That on 7/9/2022 at around 4:20 p.m. a classmate as a roommate of the petition number 2 in respect of WPC number 6695 and 6696 requested them to accompany them separately to the washroom during the games period. And on reaching the washroom, they found one of their friend along with another girl student engaging in some conversation. Now, these are the undisputed facts. Now, if your lordship kindly skips to the next paragraph, paragraph 3. In view of the meeting on 7/9/2022 itself, the petitioner students were separately called in the administration office of the school by the school authorities and were verbally threatened and mentally pressurized to give them an undertaking to the effect that they had committed some wrong and should be expelled from the school. The next date, on 8/9/2022, the petitioner students were forced to write certain self-incriminating statements against themselves, and having no alternative, they succumbed to the various mental pressures applied to them. Their parents were informed over telephone on 10/9/2022, and they visited the school on 11/9/2022. The respondent number 4 issued an order of suspension in respect of the petitioner number 2 in WPC number 6695 of 2022 from school with effect from the same date. As for the parents in the other 2 writ petitions, they were asked to take their child home till the conclusion made by the school disciplinary committee, who was said to be looking into the matter. Now, if your lordship kindly turns to the next paragraph, according to the petitioners, prior to the suspension of the petitioners, students orally and in writing, no show cause notice was issued to them, nor was any opportunity given to them to enable them to explain their stand before the school disciplinary committee. It is the further case of the petitioners that the petitioner students were forced to apply for the transfer certificate, and after being warned that if the same was not applied for, they would be nevertheless issued the same with certain remarks, which would create some difficulties for the petitioner students to pursue their further studies in other institutions. Faced with such a situation, they were forced to apply for the transfer certificate, which accordingly was then issued to them, being aggrieved there before this court. Now, these were the arguments before the learned single judge. Paragraph 6. If your lordship kindly turns to paragraph 6, my lord, it says, the learned counsel further submits that the petitioners were not informed about the charges which, according to the respondent authorities, have been violated. The alleged incident was said to have happened on 7/9/2022, and the school disciplinary committee by the next date, that is on 8/9/2022 itself, had concluded their so-called inquiry against the petitioner students in gross violations of the principles of natural justice, and therefore the decision to suspend them and issuance of the transfer certificate cannot be sustained in law and should be set aside. The learned counsel, in support of his submissions that no opportunity was given to the petitioner students to explain as to why they should not be suspended or be given transfer certificate, besides not being issued any charges which they were alleged to have committed, has relied upon the following authorities. So I'll place these authorities, my lord, during the course of my arguments. And if your lordship kindly turns to, my lord, I'll only point out the relevant paragraph, paragraph 8, page 48. If your lordship sees paragraph 8, my lord, I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record, including the application for the issuance of transfer certificate submitted by them and the petitioner students. Now, the next paragraph, the 4th line from top, my lord, from bottom, the line starting from "there is no doubt." Has your lordship got it, my lord? There is no doubt to the fact that the petitioner students are in their mid-session, and therefore, under ordinary circumstances, transfer certificate 1 would not apply for the same. But yet, in the present case, according to the respondent authorities, the transfer certificate was given on their own application. The petitioner in WPC number 6695 is also said to have registered himself for appearing in matriculation for academic year 2023-24 under the CBSE from the Sage School in Gwalpara. Therefore, this line is very important, my lord. Therefore, it appears that there was compelling circumstances leading to the submission of application for transfer certificate by the petitioners. Now, these are the fact findings of the learned single judge, and the operative portion, my lord, will find in the next page, page 50, paragraph 13. Because they have relied, my lord, to justify the impugned action, they have relied on clause 3.32 of the Sainik School regulations. Now, 3.32 says that on withdrawal ground, the petitioner, the principal can expel anybody. But this honorable court has been pleased to read the principles of natural justice into that clause, which your lordship will find at paragraph 13. Paragraph 13, my lord, I'll just read out. The above observations and findings of the apex court is also found to be squarely applicable to the present case, as the respondents have taken the stand that the clause 3.32 of Sainik School Society, which is the provision for withdrawal on disciplinary ground, does not contain any provision for issuing a show cause notice to the cadets, and accordingly, there is no requirement of issuing a show cause notice to the cadets before issuing an order of withdrawal, and accordingly, there was no requirement of issuing a show cause notice to the petitioner students. Now, this is how the learned single judge dealt with the, my lord, clause 3.32. Just because it, my lord, gives them the power, it is not unfettered or arbitrary power. Principles of natural justice has been read into it, this clause 3.32, which they have even relied on this third round of litigation, my lord. And if your lordship kindly turns to the next page, the concluding part, page 51, paragraph 15, my lord, I'll just read out that upon due consideration of the case in its entirety, I am of the considered view that there has been gross violation of principles of natural justice on the part of the respondent authorities in deciding the proceedings against the petitioner students by suspending them from the school and thereafter issuing them the transfer certificate. The same is found to be unsustainable, and accordingly the respondent authorities are directed to allow these petitioner students to resume their respective class and their respective place in the school. The transfer certificate issued to each of the petitioner students shall not be acted upon. So this is what, my lord, the learned single judge had concluded. Now, my lord, against this order, my lord, they went for a writ appeal before the Honorable Division Bench. There was no stay, my lord. In spite of there being no stay, they did not allow us to resume studies, my lord. And this is what the learned Division Bench also had to say. Honorable Division Bench, order starts at page number 53, the judgment. It starts at 53. I'll not trouble your lordship with the entire judgment. I'll only point out the relevant paragraphs. Those start from page number 61, my lord. Page number 61. I'll only read out the relevant paragraphs. Page 61, paragraph 15. This is what the learned Honorable Division Bench has to say. Page 61, my lord, paragraph 15, my lord. From the records, it appears that the inquiry was held in a summary manner. As regards the disciplinary proceedings against the students, no specific rules have been laid down as to how such disciplinary proceeding has to be conducted as regards framing of charges, hearing of the students, etc. We have also noted that the present 3 students were actually not directly involved in the act of indiscipline or misconduct, but appeared to have collaborated with the perpetrators in their misconduct or act of discipline. Though it is not the case that the students did not participate in the inquiry proceedings, but it would be desirable that if in such an inquiry is held, if it may result in serious consequences of withdrawing from the school, which literally amounts to expulsion from the school, adequate opportunity ought to have been granted to them to explain their position, more so when they have taken the specific plea that they were compelled to write self-incriminating statements. Now, if your lordship kindly turns to the next paragraph. Further, we have also noted that the writ petitioner students have made specific pleadings in their writ petitions that their parents were compelled to apply for the transfer certificates, which has not been specifically denied by the appellants in the proceedings before the learned single judge. Therefore, the submission advanced by the writ petitioner students that their parents were compelled to apply for transfer certificate cannot be brushed aside lightly. And under these circumstances, we are not inclined to interfere with the findings of the fact recorded by the learned single judge that the disciplinary proceedings against the writ petitioner students were not conducted by giving proper opportunity to the students to explain their position, and also that the transfer certificate were issued under compulsion. We are of the view that before the school authorities takes any steps which would have serious consequences for a student, utmost care ought to have been taken. Accordingly, we are not inclined to interfere with the decision of the learned single judge. The next paragraph, my lord. However, we are also mindful of the fact that there cannot be any impediment or hurdle on the school authorities to take such appropriate actions to maintain discipline in the school in accordance with the law, and the order of this court should not come in the way of the school authority to take appropriate steps as it may deem fit for maintaining discipline in the school. However, as discussed above, the same ought to be done with care, caution, and after giving proper and adequate opportunity to the concerned students. Accordingly, we decline to entertain these appeals and are disposed of, however, with the observation that the school authority shall be at liberty to take such appropriate steps as it may deem fit for maintaining discipline in the school, which, however, has to be done by strictly adhering to the principles of natural justice. The school authorities are directed, once again, my lord, this is a second direction, are directed to allow the school students to resume their classes as directed by the learned single judge, which, however, shall be subject to any of the option as the school authorities may deem fit by following the principles of natural justice as discussed above. Now, this is what the learned Honorable Division Bench had to say. We visited the school for resumption of studies, my lord. They did not allow us. We have pleaded it, they have not denied. So what we do, my lord, we had to come before this court through a contempt petition, my lord. And finally, when we filed the contempt, my lord, noting the seriousness in the matter, if your lordship kindly turns to page number 68, my lord. This is what this honorable court had to say. Page number 68, the last page of the writ petition. In the contempt, there was an order dated 2/2/2023. As directed by the court, Mr. So-and-so, learned Deputy Solicitor General of India, as well as so-and-so, learned CGC have appeared in the matter. During the deliberation of the matter, it is placed before the court that the authorities in Union of India and Sainik School have preferred a writ appeal against the common judgment and order dated so-and-so, my lord, passed in so-and-so, which were considered by the Honorable Division Bench of this Honorable Court 25/1/2023 and passed orders in the open court. List on so-and-so, my lord, enabling the learned Deputy Solicitor General of India to place the relevant information. Now, when the matter was, my lord, placed before one of the most senior officers of the central government, then finally, my lord, they allowed what they do in an attempt to circumvent both the concurring judgments of the learned single judge and the honorable divisions. What they do, my lord, very interesting. Your lordship will find at page 64. This is what they do. To show artificial compliance, this is what they do. Page number 64, my lord. The contempt order was filed on 2/2/2023. That it was passed on 2/2/2023. 2 days thereafter, on 4/2/2023, page 64, my lord. It says it is addressed to the petitioner number 2, the petitioner number 1, the mother, Mrs. Gitabali Sinha, and it says notice for reporting to the school. Please refer writ appeal number so-and-so and writ appeal number so-and-so. And the next line is important. In compliance with the judgment and court order dated 25/1/2023, your ward is hereby directed to appear before the Standing Committee on Discipline at 11 hours on 6/2/2023. So they don't allow us to resume school. They give us a notice asking us to appear before the Standing Committee on Discipline. So this is their understanding of the concurring judgments of this honorable court, my lord. So on 4/2, they ask us to come on 6/2. We go on 6/2/2023, my lord. We go, and what they do, your lordship will find at paragraph 20, page number 12, my lord. Page number 12, paragraph 20. This is how they comply with the concurring judgments of this honorable court. Page number 12, paragraph 20. That on 6/2/2023, the petitioner number 2 visited the Sainik School Gwalpara at around 9 a.m. along with her luggage. She was accompanied by her father, Shri so-and-so. The petitioner number 2's father was asked to wait in a waiting room, heavily guarded by 2 army officials. The minor petitioner number 2 was once again taken to a secluded room. The officials in the said room asked her around 19 questions in a very intimidating manner and style. She was also asked to write answers to some questions. She was not allowed to take assistance of her father, who accompanied her to the school premises. Several cameras were fixed upon the petition number 2 minor as if she was interrogated on the charges of murder or terrorism. The petition number 2 minor was interrogated for around 2 hours. So they start interrogating me, and my lord, by evening around 5:40 p.m., they give us a transfer certificate, which your lordship will find at page number 65. Page number 65, my lord. This is the second transfer certificate. Serial number 20, my lord. Date of issue of certificate is 6/2/2023. Same day, my lord. I was asked to appear before the Standing Committee on Discipline. I go and appear. They take me in a secluded room. They interrogate me in a very different manner. And on the same day, they give us this, my lord. Reason for leaving school, disciplinary ground. And in a single stroke of pen, my lord, my entire academic career is sought to be, my lord, nullified. In a single stroke of pen. This is how they conduct themselves, my lord. I come before this honorable court immediately. I immediately came, my lord. Your lordship again gave her interim protection, my lord. There's an order dated, my lord. If your lordship kindly sees, there's an order dated 8/2, my lord.
In the present,
my lord, in this present writ petition, my lord, there's an order dated 8/2/2023. We file on the next day, 7/2 and 8/2/2023, the first order, lordship's order, my lord, 8/2/2023. Heard Mr. So-and-so, I'll just point out the last paragraph. In the interim, my lord, the transfer certificate dated 6/2/2023 issued to the petitioner number 2 shall remain suspended and the petitioner number 2 shall be allowed to resume his classes. Now, your lordship also gave me a interim protection. Now, 3 orders. First, learned single judge. Second, my lord, honorable division bench. And this is the 3rd order by your lordship. This also they don't comply. This also they don't comply. And again, my lord, the matter was finally, after the intervention of the learned, my lord, Deputy Solicitor General, I was allowed to resume studies only on 13/2/2023. I've annexed that order, my lord. Page number 122, running page. Running page 122, my lord. Running page 122. My lord.
Reply affidavit.
My lord, my reply affidavit, my lord. I've annexed that order because this was a subsequent development, so I could not bring in the writ petition. Page number 122, heard Mr. So-and-so submits that students have been allowed to resume classes with effect from 13/2/2023. So after the 3rd order of your lordship, they finally allowed us, and that too on the kind intervention of the Deputy Solicitor General of India. This is the, my lord, defiance. 16/2. Now, my lord, my grounds are pretty simple, my lord. Firstly, my lord, there was no show cause at any point of time, my lord, intimating me the charges. This is ground number 1. These are all undisputed. Secondly, my lord, the honorable division bench at paragraphs 15 and 17, which your lordship will find at page 62, page number 62, my lord. Page number 62, your lordship will see paragraph 15 and especially paragraph 17. I've already read out, therefore I'll only point out the relevant line. Page number 62, my lord. The honorable division bench said that if they want to take any appropriate action,
Yes.
page number 7, paragraph 17, the honorable division bench said the last 4 line, the line starting from however as discussed above, if they want to take any, my lord, appropriate action, the same ought to be done with care, caution, and after giving proper and adequate opportunity to the concerned students. So this is what the honorable division bench said. That also they violated. They call us on 6/2. We go on 6/2. No show cause, nothing. Immediately they put us in a secluded room, and immediately, my lord, they gave us this fresh transfer certificate. And with a single stroke of pen, my entire academic career is sought to be, my lord, curtailed. And thirdly, my lord, the chronology of events, the chronology, it itself reflects that the vindictiveness of the authorities, which are apparent from the face of the records, it's very clear. Well, they have come with a vindictive, predetermined mind. And my lord, the effect of this penalty is such, it's of such serious consequences, because no other school is going to take me, my lord. Once they put disciplinary ground, no other school, I will not be able to secure admission in any other school. So my entire career is sought to be wasted, my lord. And my lord, for a penalty of such serious consequences, my lord, the charges will have to be proved. In the instant case, there is no charges, my lord. There's absolutely no charges. There's no statement of allegation. There's no, no show cause. When there is no charges, there's no question of proving any of the charges. And my lord, my next submission would be the ego of the school officials, my lord, that cannot override the mandate of the concurring judgments of the learned single judge and the honorable division bench. They might try to circumvent these orders in some manner or the other, but the language employed by both the forums are very clear, my lord. They cannot circumvent, they cannot basically play with court's orders, my lord. That is what they have exactly been doing. And just, my lord, I'll just place one, my lord, section. Right of children to free and compulsory education act 2009. If your lordship kindly sees section 2C, the right of children to free and compulsory education act 2009. Section 2C, my lord. It defines a child. 2C. Child means a male or female child of the age of 6 to 14 years. And if your lordship kindly turns to, skips to section 2F, 2C and 2F. 2F says elementary education. Elementary education means the education from first class to 8th class. Now, this child was in, my lord, 7th class at the time of cause of action. Now, if your lordship kindly turns to section 16.4, my lord. 16.4. It's a statute, my lord. Section 16.4. It says, no child shall be expelled from a school till the completion of elementary education. That would mean a child from class 1 to class 8 cannot be expelled under any circumstances. This is a statutory prohibition. And section 17, my lord. Section 17 says, no child shall be subjected to physical punishment or mental harassment. Now, what the school authorities have been doing this to this child is simply mental harassment, running from one court to other court to another, from single bench to division bench to contempt. Again, this third round of litigation. This is nothing but mental harassment. And the concerned persons are, the impugned actions are violative of section 17(1) because they cannot subject a child to mental harassment. And my lord, section 17(2), it says, whoever contravenes the provisions of subsection 1 shall be liable to be disciplinary action again under the service rules applicable to such persons. So these persons are actually, my lord, liable for disciplinary action under this statute. And my lord, even on merits, I'll make one submission, my lord. Even on merits, there was an amicus appointed. She is not here today. Senior counsel, Mr. B. Bhuyan. Now, she had gone through because they had only two arguments before your lordship. One is some CCTV footage, which is a very rare, very vague allegation. Now, this CCTV footage was examined by the learned senior counsel who was appointed as amicus. And the said learned senior counsel had found nothing incriminating against this petitioners, my lord.
She filed an affidavit.
Yes, my lord. There's a report by the inquiry. There's a report, my lord. Your lordship will find there's one report. If your lordship kindly turns to the report.
Which the report?
My lord, it must be in the records, man. This was submitted by the learned senior counsel B. Bhuyan. This is a report. It was submitted on 19/4/2023. Now, if your lordship kindly turns to paragraph B, my lord, second page, paragraph B, it's a 3-page report, small report, my lord. Paragraph B, my lord. I'll just read out, my lord. While comparing the record to that of CCTV footage, it is discernible that except for the movement of students, the CCTV footage provided to us do not show any sensitive contents that have been narrated in the records. So these records have been, my lord, prepared in a manner which is not based on the CCTV footage. This is where the vindictiveness is apparent before your lordship.
Where is the appointment of the amicus curiae?
This is an order, my lord. This is an order of this honorable court. I'll just place the order, my lord. There's an order. If your lordship kindly, I'll just point out the order, my lord. There's an order of this honorable court. 33/2023. There's an order dated 33/2023. 33/2023. Second paragraph. MS B. Bhuyan, learned senior counsel, and MS B. M. Bormon, learned counsel, are appointed as amicus for the court in the matter. They, along with the learned counsel for the respondents, shall go through the CCTV footage and thereafter shall submit the report. Now, this report is before your lordship, and they've already filed it on 19/4. And paragraph B, the second page of the report, if your lordship kindly sees, my lord, it says, my lord, I've already read out paragraph B. They have found there's nothing what have been narrated in the records. So basically, the entire records have been made in a very vindictive manner, which has no correlation with the CCTV footages. And I'll just finish if you don't mind, and you can continue. And if your lordship kindly turns to paragraph C, I'll just conclude my arguments. Paragraph C, my lord. We are of the opinion that as we are not part of the school discipline committee, neither we are getting any chance to interact with any of the stakeholders in respect of the incident in question. we would like to confine ourselves to the visualization of the CCTV footages, propagating the involvement of the petitioners herein only without giving any opinion remarks on the findings regarding the SCOD committee report specially mentioned in clause A to E. So far as the findings at clause F is concerned, which inter alia provides that cadet so-and-so and cadet so-and-so are regular companions of cadet so-and-so and so-and-so during their all previous meetings, the position of those students are there. But now this is the most important line, the last line of page number 2. But the CCTV footage only indicates the movements of them towards the boys' washroom. Hence, presumption can be drawn that they might accompany so-and-so and so-and-so on the day of the incident to some prohibited area, but their self-involvement in any undisciplined act cannot be ascertained from the CCTV footage. So even on merits, my lord, for a moment, I'm forgetting the principles of natural justice. Even on merits, there is nothing against me. And my lord, even assuming for a moment that there were charges, even assuming that they were proved, a penalty which is completely disproportionate have been imposed on me, my lord. My lord, in this connection, I would like to place few judgments, my lord. Bhavendra Kumar Kolita versus Union of India, my lord. It's a same school, same kind of disciplinary action, and this is what this honorable court had to say way back in 28/7/1995. Bhavendra Kumar Kolita versus Union of India. In fact, this has been relied by the learned single judge in the first round of litigation. I'll just point out the relevant paragraphs. Paragraph 1, my lord, just so as to understand the facts. The petitioner has filed this application under Article 226 of the Constitution challenging the Annexure 1 order dated 23/12/94, by which the petitioner's son, cadet so-and-so, was withdrawn from school with immediate effect, and prays for an appropriate writ or direction to allow the petitioner's son, so-and-so, to continue his studies in class 8 in the school, and also to allow him to appear in the promotional annual examination. The facts of the case may be stated in brief as follows. The petitioner's son, so-and-so, who is aged about 14, was admitted in class 6 of Sainik School, Gwalpara, of which respondent number 2 is the principal. The school is a member of the so-and-so. And if your lordship kindly turns to the next paragraph. On 9/12/94, the petitioner's son somehow could appear in his paper. However, being subjected to severe ragging, compelled him to leave the school on 9/2/1994 and came to his parents. On 24/12/94, the petitioner received Annexure 1 letter from the second respondent, whereby he was informed that son has withdrawn from the school on gross disciplinary grounds, as he left the school on so-and-so without permission of the school authority, leaving an objectionable note. According to the petitioner, this action was taken by the second respondent on his own, without giving any opportunity to his son or to the petitioner to explain the position. Now, if your lordship kindly turns to the operative paragraph 9. I just placed the facts. Now, this is what this honorable court had to say. Paragraph 9. I'll just read out, my lord. Page number 3, my lord. Paragraph 9, my lord. Paragraph 9, my lord. The last paragraph, my lord. I'll just read out, my lord. Under what circumstances the petitioner's son had to leave the school? From the record, I do not find anything to show that the petitioner was given an opportunity to explain under what circumstances he had to leave the school. Of course, in the affidavit in opposition, the respondents had annexed Annexure C statement said to have been written by the son of the petitioner. As per the averments, the petitioner's son left on so-and-so, and therefore he was caught by the housemaster and some other students, and a statement was written by him as averred. Under what circumstances this note was written is not known. The possibility of writing the said note under influence or under threat of some persons cannot be ruled out. Instance of this nature is not unknown. Besides, it is also well known that the vogue in educational institutions, several students in many educational institutions suffer from the menace of ragging. Therefore, no drastic action in such circumstances should be taken without first making proper inquiry and without the compliance of the principles of natural justice. However, rules of natural justice cannot be put in a straitjacket. The concept of natural justice envisages the principles, namely, number 1, no one shall be a judge in his own case. Number 2, no one shall be condemned unheard. The second principle envisages that the right to be heard in order to be effective must be preceded by a notice. As to an extent of the charge which a person is called upon to meet, person must be given an opportunity of presenting his case and in such a case suitable to the character of the inquiry, which would ensure a fair hearing resulting in fair dispensation of justice in administrative law. Rules of natural justice are foundational and fundamental concepts, and the law is now well settled that the principles of natural justice are parts of the legal and judicial procedures and are also applicable to the administrative bodies in its decision-making process having civil consequences. And the Honorable Court had relied upon, my lord, that Rash Bihari judgment 94-5 SCC 267, my lord. It says, the paragraph, I'll just point out the relevant, relevant portion. It says, my lord, from the bottom, that paragraph 6, which has been quoted, 4, 5, 6. 10th line from the bottom, the line starting from where the statute is silent. Has your lordship got it, my lord? Where the statute is silent and a contrary intention cannot be implied, the requirement of the applicability of the rule from natural justice is read into it to ensure fairness and to protect the action from the charge of arbitrariness. This is exactly what the learned single judge had done in the first, my lord, round of litigation. And if your lordship kindly turns to the next page, paragraph 11, the concluding paragraph, paragraph 11, my lord. In the present case, the petitioner's son, a minor student, left the school and he was caught on the next day by the housemaster of the school and some others. And he was asked to write a statement and he wrote it. In such a circumstances, there is every possibility of threat or some pressure. At least he was under some severe mental pressure. Therefore, a charge ought to have been framed against him and the authority ought to have given notice calling for explanation. The boy ought to have been given some time to get over the fear psychosis he might have been having under the fact and circumstances, member. And finally, the next paragraph, if your lordship kindly turns to the next page, paragraph 12, the last paragraph. Therefore, in my opinion, the impugned order is arbitrary and violative of the principles of natural justice. Accordingly, I set aside so-and-so order and also so-and-so reply letter. From the record, it appears that this court, as an interim measure, directed the authority to allow the petitioner's son to appear in the examination. Learned counsel for the parties have also informed this court that the petitioner's son was allowed to appear in the examination. In view of that, I direct the authority to declare the result immediately within a fortnight. So way back in 1995, my lord, your lordship had protected my lord, such students who were before. And there's another judgment, my lord. I'll only point out 2 paragraphs. Praveen Basnet versus State of Sikkim, paragraph 12. I'll not trouble your lordship with the entire judgment. Paragraph 12, my lord, page number 4. Here also disciplinary proceeding. Paragraph 12, my lord, page number 4. Paragraph 12, I'll just read out, my lord.
Yes.
Paragraph 12. A bare perusal of the impugned expulsion orders reflects that not a single instance of any breach of the rules has been mentioned in it. On a pointed question to the learned Additional Advocate General as to whether the impugned expulsion order was preceded by a show cause notice, he has very fairly stated that there was no show cause notice issued highlighting the various instances of the breach of the rules. The learned Additional Advocate General pointed out the minutes of the meeting dated so and so in reply to the query as to what were the breaches that were alleged in the impugned expulsion order. A perusal of the minutes of the meeting reflects that the meeting was of the head of the departments alleging that the students had violated the rules by staging dharna. Neither the petitioners nor other students were part of the meeting convened on 10/2/2022, in which it was recorded that the 21 students named therein were identified for violation of the institution rules and regulations by staging dharna without seeking prior permission from the students. And I'll just point out the next paragraph, paragraph 17, the concluding part. They were allegedly, paragraph 17, my lord, the concluding part. Having said that, paragraph 17, my lord, having said that, on examination of the records of the present case, it is noticed that there has been a complete violation of the principles of natural justice. The impugned expulsion orders have been passed without giving an opportunity to the petitioners to show cause as to why such an action as was resorted to ought not to have been taken. There is no material even at this stage on the perusal of the counter affidavits allegation, which reflects that the authorities applied their mind to the evidence to establish the allegations and thereafter to pass the impugned expulsion orders after affording an opportunity to them. The impugned expulsion orders as well as the decision for their expulsions taken by the general body dated so and so in such cannot be sustained. And the Honorable Court had interfered, my lord. If your lordship kindly takes the next judgment, my lord, is a Madras High Court, my lord. Supreme today judgment, my lord, C. Arun Prasad, my lord. C. Arun Prasad, paragraph 5. Only the relevant paragraphs I'll point out. I'll not trouble your lordship with the entire judgment. Paragraph 5. It says, it is true that no hard and fast rule can be laid down with regard to the disciplinary action to be taken against a student. It is also true that this court should be very slow in interfering with the matters of enforcement of discipline, and the technicalities of law should not be imported to further the cause of a student who had indulged in indiscipline. However, if the facts of the case before me are looked upon, I do not see any ground to sustain this summary order of expulsion passed by the school authorities. Files do not show that any sort of inquiry has been done. The headmistress seems to have sent for the petition and others, and they refuse to tender apology. But when the staff council had passed a resolution as found in the files, number of charges are seen against the petitioner and the others. The petitioner seems to have been expelled on a number of charges which are not known to him, and no inquiry is seen. This itself is sufficient to set aside the impugn order before this court, as it violates the principles of natural justice. And next paragraph, paragraph 6, the last paragraph. Though I find on perusal of the files that the complaint has been filed against the petitioner to the headmistress in charge and the police, no whisper has been made in the counter affidavit filed before this court. Except the bare resolution passed by the staff council, no other material is found in the files warranting expulsion of the petitioner herein. If the expulsion of the petitioner is to be sustained, principle of natural justice ought to have been followed. No notice indicating allegations or charges is found in the files. This is held to be bad by a division bench of Bombay High Court in so and so, my lord. Even in the counter affidavit, I do not see any allegation against the petitioner that he is responsible for the incident of assaulting a teacher according to the complaint as found in the files. Though the files show that the complaint has been made by one Sri Radhakrishnan teacher stating that the petitioner had come and threatened him, no mention is made in the counter affidavit about the said complaint because no inquiry has been made on that complaint. That apart, I do not see any justification in the action of the respondent of school in readmitting other students who have been kept under suspension initially and expelling the petitioner alone. Though the learned counsel appearing for the respondent school states that the petitioner is a ringleader and he has got to be expelled, as I have already stated. It is to be done following the principles of natural justice. It has been done. It has not been done here. It has been held that when the order of expulsion is a quasi-judicial order, like in the present case, there should be sufficient compliance with regard to the principles of natural justice. In my view, the student in this case ought to have been informed about the charge or the allegation he has to meet, and he ought to have been given an adequate opportunity to meet the said charge. Accordingly, my lord, this honorable court interfered. And my lord, the last judgment, if your lordship kindly takes, it's my lord, Master Vatsal Khakharia. This is Chhattisgarh High Court. Recent judgment, 2018. I'll not trouble your lordship with the entire judgment. I'll just point out the basic premise, factual premise, and then what the court had held. Paragraph 1, my lord. This is where we'll find the facts. Paragraph 1. The petitioner was a student of class 8 in Delhi Public School, Durg. For the academic year 2017-18, he was not allowed to appear in the examination of the said class by the school authorities, but the order of the District Elementary Education Officer, Durg, on 9/4/2018, he was allowed to appear in the examination. However, he appeared only in 4 papers and remained absent in 2 papers. His results was declared on 28/3/2018, but he was not promoted to class 9, leading to filing of the writ petition, inter alia stating that right of education up to the age of 14 years is a fundamental right guaranteed under Article 21A of the Constitution of India, and by virtue of the provisions contained in Section 16 of the Right of Children to Free and Compulsory Education Act 2009, no child admitted in a school shall be held back in any class or expelled from the school till the completion of elementary education. This is basically a reiteration of the statute, my lord. Since the petitioner was a student of class 8, which also comes within the meaning of elementary education, therefore the respondent school is not justified in holding back the petitioner and not promoting him to class 9. And as such, an appropriate writ be issued directing the respondent school to promote the petitioner. And this is very important. The last same page, last paragraph 6, my lord. Paragraph 6, the last page, same page. May I just read out, my lord? The Parliament has amended the Constitution of India by inserting Article 21A by the Constitution, 86th Amendment Act 2002, on the basis of the law declared by the Supreme Court in the matter of J.P. Unnikrishnan versus State of Andhra, 1993, 1 SSS 645, holding that the right of education up to the age of 14 is a fundamental right to every citizen under Article 21 of the Constitution of India, pursuant to which the children up to the age of 14 are guaranteed to get free and compulsory education. Article 21 has been quoted, which I'll not read out, my lord. And next page, paragraph 8, my lord. Paragraph 8, I'll just point out the relevant paragraph. In order to appreciate the point in dispute, it would be appropriate to notice the definition of the child. I've already placed the definition before your lordship, and the definition of elementary education enumerated in clauses 2C and 2F of the Act of 2009. I've already placed that. And the last paragraph, paragraph 16, the concluding part. Paragraph 16, my lord. Be that as it may, since section 16 of the Act of 2009 as it stands today statutorily prohibits the school to hold back a child in any class till completion of elementary education, the act of the respondent number 3 in holding back the petitioner and not promoting him to the next class is held to be arbitrary, not in accordance with section 16. Accordingly, respondent number 3 DPS is directed to award a certificate as provided in section 30 of the Act. The petitioner in such a manner prescribes certifying that he has completed his elementary education and necessary report card be issued to him within a week from the date of the receipt of the certified copy of this order. So this is how, my lord, section 16 has been interpreted. They cannot prohibit, my lord. There's a statutory prohibition, my lord. So, and the last limb of my argument, my lord, I'll just place. Now, how are they justifying? What is their ground? How are they justifying the impugn action? The stand of the authorities. If your lordship kindly takes page number 76, my lord. Page number 76, running page 76, paragraph 11. This is completely atrocious. This is how they justify the impugn actions. Paragraph 11, my lord, page number 76. Running page 76, paragraph 11. Now, my lord, they say, paragraph 11, page 76, my lord, this is their counter affidavit. Now, this is their stand. This is how they justify the impugn actions. What they say, that with regard to the statement made in so and so of the writ petition, the deponent begs to say that Sainik School Goalpara is governed by Sainik School Society rules and regulation. Clause 3.32 of the Sainik School are as follows. Behavior on influence in the opinion of the principal
May it please your lordship.
Oh. The first matter. Yes.
May it please your lordship. My lord, last occasion, I just recollect the lordship. Regarding last occasion also, lordship was pleased to add the matter, lordship, regarding the selection of
This
19.
court did not hear you, I think. This court, some other court heard you.
Lordship, this
One
court also
minute.
prior to that, lordship.
না করুন করিলে তো আপনি ঠিক তো করিলে Yes.
Lordship, here in this case, lordship, petitioner before your lordship, she is a selected candidate, lordship. Her name appeared in the select list, lordship.
Let's see the advertisement.
Lordship, advertised copy, lordship, I have no, could not annex, lordship, because my name is appeared at page 42, lordship, in my writ petition.
This is a select list.
Lordship,
Oh.
it is an advisory board select. They have admitted my position, lordship, in their last affidavit, lordship. Page 235, sorry, for page 42, my name is 235 serial, lordship. Hudeja Khatun Chaudhary. Then, lordship, the below her name, they were appointed, lordship. But my case was not considered. But lordship, the honorable division bench, lordship, page 88 and 89. Just time.
Which
Sorry. Page 88, lordship, may I read, lordship? First 87, lordship, may I read last paragraph? By judgment and order of civil rule number 2160 of 90, the bench of this court, page 88, lordship, directed not to appoint any other person to the post of LP school teacher outside the list, and further directed that the appointment shall be made till the list is exhausted. Such a direction had to be issued, as in the meantime, another advertisement was issued. But lordship, in this page 88, last paragraph, lordship, first objection of Mr. So and so, select list for this district of Hailakandi is expired on 31/12/90, but the present petitioner were filed dated so and so. In this ground, learned additional advocate has raised objection. We are unable to accept the contention as per direction in the above civil rule, and that all appointments in future shall be made till the list is exhausted. So here is my right, lordship. Below me, persons were appointed. Then, lordship, page then page 89, we find that all future vacancies, page 89, lordship, middle portion. We find that direct that all future vacancies in the district of Hailakandi shall be made only from the said select list, and no fresh candidate shall be appointed till the list is exhausted. My restored submission, lordship, by virtue of that, lordship, till date, lordship, I am entitled to get, since below me persons are appointed. And there was accordingly, lordship, page 9.
What is the date of this select list?
Select list is a page 88, 89. That is 1991, lordship, interview was held. Then, lordship, page 99, back for a moment, lordship, just I am giving the background. Page 99, lordship. May I read, lordship?
Page
99, lordship, annexure 2D.
Yeah.
There was also contempt, lordship, for which the director passed the order. Sir, with reference to the subject, I am directed you to comply with the orders passed by the court by appointing the following petitioners as LP school teachers against the existing available at your disposal, since limitation for filing review application has already expired. long back as stated in a letter and the contempt proceeding has been pending so and so regarding the same matter. That lordship, my name is Kudeja Khatun Choudhury, serial number 6. All others were appointed up to 1 to 5, lordship. Then lordship, page 100. It's an approval of state level empower committee. Page 100, lordship. I am directed to refer to this letter on the subject cited above to inform you that the governor of Assam is pleased to accord ex post approval for filling up the 6 numbers under your jurisdiction, a direct recruitment as per order of the Honorable High Court. Lordship, here they have included another person in serial number 6, Azmat Ali Choudhury, whose name is appeared at serial number 379 of the select list, lordship. 379. Just lordship, I'm coming, lordship, his name. Lordship, page 45. 379. Last but one, 379, Azmat Ali Choudhury. Then lordship, some others were appointed, but my case was not considered. Then lordship, civil suit was also filed. There was some technical difficulty as raised by the government also. Then lordship, my case name was forwarded by the Deputy Inspector of School on 2010 also, page 114. Page 114, lordship. It was 1/11/2010. Last, lordship, last 4 paragraph, may kindly lordship, 5 paragraph. Later, in compliance of the Honorable High Court's order and decree given by the district assistant district judge in persons of the government so and so, so and so. But the case of the petitioner of the representation, Srimati Kudeja Khatun, is still pending. Her case was also referred to the government by this office letter so and so, so and so. It may be mentioned a case of this and other plaintiffs degree holders. Mention office undersigned has been gutted. It is also worthwhile to mention that the office of the undersigned have been gutted by fire accident on 18 September 99. All the records and other properties of the office were also gutted by the fire. However, as soon as Srimati Kudeja Khatun Choudhury approached and submitted her relevant documents, her case was also submitted to the government, copy enclosed, but no intimation, communication is received yet. This is for of your kind information and necessary action. Lordship, how the petitioner will deprive lordship. Then lordship, page 123, annexure 14. 123, lordship. 123. It was a letter issued by the Director, Elementary Education on 12 June 2014. The commission to the Commissioner and Secretary so and so, so and so. Sir, with reference subject, I have the honor to submit here with the SIU proposal of a vacant sanction post of LP school teacher, Hailakandi district, financed along with all relevant documents so and so. Permanent detention letter in connection with the court case of so and so, Srimati Kudeja Khatun as sought for by the government so and so. This is for favor of a kind information and necessary action. That communication was there, lordship. Then lordship, all formalities were completed, lordship, but subsequently on 113, lordship, page, annexure 16. This was the SIU approval, lordship. For SIU approval, 113, lordship, page. Annexure? Annexure 16,
113.
113, Lordship.
133.
Oh, sorry, 133, Lordship. Sorry, Lordship. 133, Lordship.
Hmm.
That letter was on 31st May 2017, Lordship. Sir, with reference to subject cited above, I have the honor to submit here with the SIU proposal of one sanctioned vacant post of teacher of LP school under Hailakandi district in prescribed format, along with the relevant for post of a letter, permanent retention letter as sought by the government letter mentioned under reference. Then Lordship, that was not considered. Then Lordship, page 135, Lordship. Some communication was made by the Deputy Secretary, Government of Assam, Lordship. Then also, Lordship, page 136 also. Assistant Director, you are there once again, you could kindly submit the information as requested by this office. Then Lordship, 137, Lordship, page, it was a letter issued by the so-and-so on court case, Lordship. Then Lordship, the District Element Deputy Inspector of School, page 138, may kindly peruse, Lordship. Deputy Inspector, sir, with reference to above, I have the honor submitted detailed reports was filed by Khudeja Khatun Chaudhary, State of Assam, for favor of your kind information and taking necessary action. Then page 139, Lordship, the report. Last two paragraphs, ma'am, kindly peruse, Lordship. 5 number of petitioners in the above so-and-so miscase has already been appointed. 2 members are expired, and Srimati Khudeja Khatun Chaudhary, the only new petitioner, which case could not be considered. Later on, several proposals have been sent to the higher authority for taking necessary action and certain approval of the state level Empower Committee and approval of the Finance SIU Department to issue appointment to the petitioner, but the matter not yet disposed of until under process. Then Lordship, page 141, 5/11/2018. That was a report submitted by the DIF school to the district elementary education officer. Lordship, on query, I have the honor to forward with the required so-and-so, Srimati Khudeja Khatun Chaudhary, so-and-so. Yes, there is a court case or so-and-so, so-and-so. The select list of, then point number 2, Lordship, in page 141, select list advisory board Hailakandi where the name of the petitioner Khudeja Khatun Chaudhary exists by serial number 235 as referred in CR number so-and-so. Select list bearing the name of Srimati whose name appeared at 235 of the select list copy enclosed. This is for kind information and necessary action. Then Lordship, my name was shown. Then Lordship, the petitioner earlier approached this honorable court and the government has filed their affidavit, Lordship, page 146. Annexure 22. Relevant portion, Lordship, of the said affidavit, page 148. Paragraph 6, Lordship. Thereafter, the case of the petitioner was forwarded to the government for first time on 28/2/2001 for necessary order by the Deputy Inspector of Schools, Hailakandi, although various communications were made thereafter. However, due to non-receipt of SIU approval, the case of the petitioner could not be considered. The SIU proposal was submitted by the DEA Assam on 12/6/2014. Accordingly, DEA Director Elima Assam was asked to furnish a detailed report showing the chronological development in the matter. So Assam was further asked to submit the select list of Hailakandi district as referred in CR number. Earlier, it was a civil rule, Lordship, number 1587 of 1991, and clarified if there is any specific order of the court in favor of the so and so. Accordingly, the commissioners and government of Assam Education Department was provided with the detail as sought by letter number dated 16/11/2018, which I earlier referred, Lordship. But the said writ petition, Lordship, was rejected, dismissed, then petitioner approached the division bench, Lordship, page 154, Lordship. Operative portion, page 155.
How was it rejected?
Lordship, the rejected on the ground that the question of delay and other things, Lordship, then writ appeal. Writ appeal was allowed, Lordship, the petitioner, page 155. Operative portion, Lordship, 156. After hearing the learned counsel for the parties, 156, Lordship, last two paragraphs, we are of the opinion that where the state authorities will be willing to grant SIU approval at the stage after petitioner has reached at the age of 57 years. That the Lordship was asked, Lordship, what is the age now, my lord? If she will get the job for 2 or 3 years, Lordship, so many appointments were made, but this poor petitioner lady, Lordship, was deprived from moving from pillar to post for getting her appointment. So many communications. I am coming, Lordship. Issue which can be considered by the state authority. However, assertion made by the learned counsel for that the appellant's application for grant of SIU approval is under process is not denied by the state respondent. Under these circumstances, we allow the appeal by directing the state respondents to consider the application filed by the writ appellant for grant of SIU approval as per aforesaid letter so and so, which I referred just now, as well as statement made by the state in their affidavit, which also reflected the matter is under consideration. Then last paragraph 157. Accordingly, the impugn order 16/3/2022 passed hereby set aside with direction to the respondent authorities to complete the process which is pending before the authorities as indicated in the aforesaid documents as expeditious as possible, preferably within a period of 2 months. Then, Lordship, the director, page 158, referred the matter to the secretary to the government of Assam. Then, Lordship, 160 is the impugn order. 161, may I come, Lordship, operative portion for saving the time, Lordship. During the pendency of the proceeding of the so and so, it was moved to finance department for filling up the one sanction post of assistant teacher Hailagan. The finance department referred the matter to the senior standing council, finance department for views. The senior standing council finance has opined that no right has accrued in favor of the petitioner, namely Srimati so and so, in pursuance of the judgment so and so, so and so, so and so. In the meanwhile, WPC number so and so was dismissed by the Honorable Court, that is single judge order, Lordship, assailing the order dated 6/3/2000. The petitioner preferred writ appeal, which was allowed by order number 13/5/2000 by directing the state respondent to consider the application filed by the appellant for grant of SIU approval as per D Assam letter number 31/5/2017. Matter was moved to the, then again, Lordship, matter was moved to the senior standing council elementary education for views. And he has reiterated the earlier views dated 3/1/2002, 22 order of finance department. In view of the above stated facts and circumstances and views of this senior standing council, elementary education department, that no right has been accrued, my lord, division bench of this honorable court directed to consider, but the authority is not taking due respect to the order of the this honorable court, giving preference to the order of the learned standing council, Lordship, education department, which is, Lordship, it's with all respect, Lordship, I am very honestly submitting, Lordship. With all fairness, I am submitting senior standing council department that no right has been accrued. Lordship, once this court is directing where the question of right by deciding by the senior government advocate elementary education, Lordship, with all respect, their affidavit I am coming also. Lordship,
a lady, poor lady, deprived from getting her appointment since 1991. Others were considered, but she is singled out. So my resort to submission at this stage, let the authority consider my appointment by reconsidering the matter since they filed their affidavit. Lordship, page 162. I'm coming, Lordship. 162. That the answering report begs to state that the writ petitioner Sima Kudeja Khatun Chaudhary was one of the candidates selected for appointments district, and her name appeared at serial number 235. That does not denied. I am selected, Lordship. The candidates below rank were given appointments, leaving the present writ petitioner. Lordship, where my right? I am entitled to get my appointment, Lordship. With all respect, since others were considered, so many appointments by the government of Assam, Lordship, but this poor lady, Lordship, was deprived from several years, Lordship. Being the agree present along with other similarly situated persons, so and so, thereafter, except the petitioner, other candidates were appointed. It is stated the deponent that after passing the judgment, so and so, also appointed the present petitioner deserves similar consideration with co-plaintiffs who were already appointed, Lordship. Then, Lordship, here is also some, Lordship, they are raising some technical pleas, Lordship. With all respect, Lordship, at this stage, only 2-3 years she will get, Lordship, her appointment. At least a justice, Lordship, from this court, Lordship, she should have to get a justice at the end of her career, Lordship. I pray, let the authority may reconsider the matter without influencing the letter of views of the senior standing council, Lordship. With all respect, by virtue of the writ appeal, Lordship, wherein the Honorable Court directed, Lordship, the state has to consider the SIU approval. Then, Lordship, and consider my appointment. My prayer is that, Lordship, there may reconsider, entire matter may be remanded back since the government has admitted others were considered, but my case was rejected by, Lordship, the only declaring by the government advocate that I have no right, in spite of having Honorable Court's order, division bench order, Lordship.
Yes.
So my resort to submission, Lordship, since others were considered, below me also persons were appointed, and which is a clear violation of Article 14, Lordship. In one of the very recent case, Lordship, though that was a question of regularization, Lordship, of the Honorable Apex Court. It's a regularization of the master rule worker, Lordship. Others were, Lordship, others were considered, but some of them are not considered. The Honorable Apex Court, in the judgment only on 3rd July 2023, paragraph 8, it was held that, Lordship, though it is related to the other, Lordship, but I am relying only on that part, Lordship, since I am deprived from getting my appointment, and there is a court's division bench order, Lordship, paragraph 8, Lordship may kindly consider that part, Lordship. Indisputably, the appellants herein above completed service more than 10 years. Even this court, in the case of Ravi Verma and others, so and so, found that the act of regularizing the service of some employees and not regularizing the service of the others is discriminatory and violation of Article 14 of the Constitution of India. Lordship, my resolution submission, Lordship, with all respect, and here in this case, Lordship, the Honorable Apex Court, in paragraph 13, Lordship, the services of the appellants are directed to be regularized from the date on which the service of other parties were regularized, and the back wages to which the appellants would be entitled to shall be paid to them within a period of 6 months from today. It was a, Lordship, contempt case. And in that case, Honorable Apex Court held that below lordship, others were considered and some of them were not, which is a clear violation, lordship. In my respect to submission here in this case also, lordship, since others were considered below me and I am deprived, lordship, it is a clear violation of Article 14, lordship. And regarding the views of the law, I am not expressing, lordship, there are some judgment also. It is the duty of the government advocate is the relation between the government, lordship, is a client relation. They cannot, lordship, in one of the judgment, lordship, in 1994-1, it was held by the apex court. The relationship, may I just reading, lordship, I am not disputing whatever is there, but my respect to prior lordship, before your lordship, to consider my appointment, at least she should get something for 2 years or 2.5 years appointment, lordship. They can consider so many persons who are appointed illegal, irregular, in spite of having selection, being a poor lady, lordship. I am deprived. Others were considered, putting some question, technical question that I am not participated in. I was not there in that suit. I am not on that. There is a division bench order of this on which I referred in paragraph page 88 and 89. The Honorable Division Bench, lordship, reiterate that the further direction of all future vacancies shall be made only from the said select list, and no fresh candidate shall be appointed till the list is exhausted. In spite of that, they have appointed, which is a clear violation of this honorable court's order. I am not disputing that. I want, lordship, that poor lady, lordship, should at least get something, lordship, after repeated long years of battle in the legal field, lordship. With all fairness, I am submitting, since my learned friend is also filed their affidavit. I am not blaming anybody, whoever, lordship, I am not on dispute, though I have a judgment of some of that, the role of the government advocates, how to deal with that. Because with all fairness, I am submitting, I was also the government advocate, out of record I am submitting. I am never like that, lordship, to put the question before the authority on the order of the honorable court. It's not, lordship, with all fairness I am submitting, which will give a bad message to the people, lordship. They are the poor people, lordship. A lady, lordship, already selected. Some of them are already appointed. My name was referred to the SIU. So at this stage, I am praying, lordship, let the matter maybe refer to the government to reconsider my matter for appointment in any vacant post, whatever may be, for the rest of the period of service. Lordship, at least as per my learned friend, lordship, I am not disputing or I am not come here, lordship. Just it's a right, lordship. By virtue of this judgment, lordship, I am till today entitled. Forget about the civil suit, everything, technicalities. But the division bench of this honorable court in 1991 held that the appointment should be made till the list is exhausted. Others were appointed, I am remain. What is the fault with me, being a lady, moving from pillar to post? Several years, lordship. So my rest at this stage, lordship, without disturbing lordship, this honorable court, lordship, I pray, let the authority may consider my case for appointment in any vacant post for the rest of her age, lordship. At least she will get something, lordship, on that. This is my respectful submission to remand the matter of.
Here we have filed our affidavit. One of the judgment which relied by my honored friend of the Honorable Apex Court. That is something different, man. That is regarding regulation. But here petitioner has not appointed till that matter. After selection, she has not appointed. But that is why this judgment of the Apex Court is different on different angle.
That's fine.
Another thing is that my lord, petitioner was not a party in the civil.
Whatever it is,
My lord.
what did the division bench in the civil law say?
My lord, that division bench, my lord, in that case, my lord, petitioner was not a party, man.
I should not be party.
Whatever it is, division bench says until and unless the list is exhausted, you cannot have further appointments.
My lord,
Thousands of
initially process was there to appoint the petitioner. My lord.
And then when you considered with the latest division bench direction,
My lord,
you did not consider on the lines directed by the division bench.
my lord, here, my lord,
You diverted, your attention was diverted by the
Very good.
comments given by the standing council.
My lord. But that is a relation between client and advocate, my lord, that may be provided by the council to his client, my lord. Here, my lord, SIU approval, my lord, the finance department has taken the view from the standing.
Yeah, who's appears for finance? Have you filed your affidavit?
No, we have not filed it. Lordship, I have waiting instruction regarding the standard, but Lordship, there are previous, if I, Lordship, in page number 156, Lordship, the Honorable Division Bench had directed the respondent authority to consider the case of the petition. Lordship, I'm not going against the appellant. The consideration was needed to be made. On the basis of that, my lords, although the views have been, the views of the standing council have been referred to in the order, my lords. The order dated 31st August 22, whereby the claim, lordship, but consideration was given, my lords, and these are only the views, my lords. The final call was made by the respondent authority.
There was no consideration made, Mr. Chalia.
Lordship, that there's a speaking order basically, lordship. Maybe.
What was considered was the view of the standing council.
Lordship, that I bow down to it, lordship, but there was, the views have been incorporated. Those are views, lordship. Those are, that is the opinion, lordship. Rejection was made by the state authority, my lords. We were only, and that has been incorporated in the order, lordship. It is not like we gave a final. Those are opinions and views, my lords. So on the basis of those views, they have come to this conclusion, my lords. So, lordship, in that case, lordship, if reconsideration needs to be.
Return back to the authority, my lord.
Lordship may grant us some time, 2 weeks time, I will.
Lordship, with all respect, I'm submitting, lordship, whatever order, lordship, she is, lordship, already exhausted, lordship, nothing is, lordship. I pray with all respect, lordship, pass any order, lordship, she is harassing like anything, lordship. If they will file their affidavit, then lordship, another time, lordship, repeatedly she is moving, lordship. I pray with all, by not interfering with my learned friend, lordship, let the entire matter may be referred to the director and commissioner.
That will not help you.
Because
the director is going to pass the same order. See, Chalia, what type of instruction do you want?
Lordship, here our role is basically SIU approval if has it been given
Yes.
or not. That is ours.
Earlier it was given, isn't it?
Yes, lordship.
No.
Lordship,
No.
here
There was a process.
I do not have the exact location whether the approval has been given or not, my lords, because here the affidavit filed by the education department was stated that it is under process, my lord. That is a statement from there.
See, come to the division bench order.
Yes, lord. I mean. Lordship, in page number 156. Third last paragraph of the third paragraph from the bottom, lordship, there were certain observations. Learned counsel of the writ appellant argues that whether any effective order could be passed if the petitioner reached the age of 57 or not was not the issue before the single judge. The only issue raised by the writ petitioner was non-granting of SIU approval in respect of petitioner's appointment. However, there was no consideration by the learned single judge. Second, after hearing the learned counsel for the parties, we are of the opinion that whether the state authorities will be willing to grant SIU approval at this stage after the petitioner has reached the age of 57 or not is an issue which can be considered by the state authorities. However, the assertion made by the learned counsel for the writ appellant that the appellant's application for the grant of SIU approval under process is not denied by the respondents. This was at that moment, we were not. The education department had made a statement that they have said it. The status was not known to us, my lord. Under these circumstances, we allow the appeal by directing the state respondent to consider the application filed by the writ appellant for grant of SIU approval as per the aforesaid order dated.
So whether the SIU approval was granted or not?
Yes, lordship. That lordship, if lordship can, that I can place it within 1 week, my lordship. I can.
Yeah, make it short.
Yes, lordship, I can.
Petitioner spend her whole life in the court only.
Thursday. Lordship, I can place that instruction by Tuesday.
As per,
That is the only finance.
as per my instruction, lordship, SIU approval not given. Which
Let
is
us see from what comes from the.
Let us
order.
find out.
any in their affidavit also in the government also earlier.
I-
And also in the paragraph also they have stated in paragraph, lordship, the SIU approval not considered, Lordship.
Let us see, hear from the horse's mouth.
Yes, Lord. So we can come up with the reason why the SIU approval was not.
Don't file your affidavit, just get.
Yes, Lordship, Lordship may place it on Tuesday, Lordship, I will.
Okay.
I pray, Lordship, it's maybe part hard, Lordship, otherwise, Lordship,
Mr. K. Majumdar, that's fine.
whatever order, Lordship, with all fairness, I'm submitting, Lordship,
Also
because he
heard,
lost everything, Lordship.
Mr.
PK Bora,
P.K. Bora, understanding council,
elementary education.
elementary education. So on request of A. Chalia, understanding council, finance department. Mr. Moto, and then on. In line. As part of.
Lordship, on question of equity, Lordship, after several years, a poor lady, Lordship, so many appointments they made. My learned friend, I think, if you will feel the pain, Lordship, if in their side, Lordship. With all fairness, I have no dispute with the government or whatever, maybe Lordship is their view. But that consideration to be, Lordship, on human mind, Lordship, humanitarian things are there, Lordship, since injustices are caused to the poor petitioner, Lordship.
God bless me.
Much obliged, Lordship.
Order.
Yes.
My lord, we have filed an amendment petition. They have not replied, so amendment may kindly be allowed.
No, Lordship. They have prayed for the amendment of the prayer portion. Which cannot be, Lordship. That will change the nature and character of the petition, whole petition, Lordship. If they want to make some amendment, Lordship, they may come by way of a new petition and maybe take with this, Lordship. There is no, Lordship, we will not object to that, Lordship, but.
Are you filing your objections or not?
Lordship, without objection also, Lordship may pass order because amendment in the petition, Lordship, the pleadings that may also be, Lordship, considered, but.
What is the prayer? Let us see. Or let us see the proposed.
Amendment in the prayer portion.
Let us see the proposed amendment.
Yes, that may be in page 8, my lord. Page 8, para 4. Only this portion we want to be amended. After the words other excellences in various fields, and before the words and causes being shown, if any, the following words should be added. And also to set aside the resolution number 2 of the governing body of MDKG College Dibrugarh, resolving to accord the approval of the selection board's resolution dated 19/1/16, recommending to appoint Mrs. Mayuri Datta Fukan as the assistant professor of political science in MDKG College shall not be set aside and passed. So, our whole case is against Mayuri Datta. She is not entitled to get any marks against her experience because her PhD was obtained later on. She has no experience, but experience marks were given. So those things are there. So her selection itself is illegal. So resolution they took, that should be set aside. Everything is there in the writ petition. Only prior portion, that matter was not specifically mentioned. If the marks are given properly, automatically she will be ousted. But she was given some more marks to which she is not at all entitled for. For instance, experience, her PhD. PhD was for qualification. If the PhD is used as a qualifying degree, then she will get nothing. So the last date of submission of the application was within December. She obtained that PhD degree thereafter. So even then, masters will be given. So
that part, my lord, already my lord completed, my lord. This matter, my lord, 5-6 occasion, my lord, matter was listed for hearing, my lord. And accordingly, my lord, this honorable court, my lord, heard this matter, my lord. My lord, now, my lord, kindly see that there, my lord, read petition prayer, my lord, origin petition, origin prayer, my lord. My lord, if my lord, this prayer, my lord, IA, my lord, the amendment, my lord, then my entire, my lord, the character of the read petition changed, my lord. So, my lord, kindly see their origin, my lord, prayer, my lord, in a read petition, my lord, page 60.
You file a separate writ
Yes,
petition.
my lord.
No, my lord, that is amendment may be filed at any time before pronouncement of judgment.
Amendment can be filed at any time, but amendment we should not change the character. of the
Yes,
writ
yes,
petition.
that is true, my lord. What character would be changed? Because our case is that within the whole case, those things are there. But in prior portion, that was not specifically mentioned.
My lord, kindly see the writ petition, my lord, their prayer, my lord.
Yeah,
That's
that I'm admitting in prior portion, that was, this resolution was, because actually that resolution was,
Page 16, my lord.
suppose Lordship may kindly see, page 16, to give adequate marks to the petitioner for her experiences and other qualifications, etc., considering the peculiar facts and circumstances of the case, as well as for her teaching experience, her publications, and other excellencies in various fields. So if these marks are given, then automatically I will be in the first position. Now I am in second position. So automatically the resolution shall be ineffective. So in that view, thing is there. In our case, we have stated that she was given.
Already, my lord, they petitioner
One
filed,
minute,
my lord,
one
6, my lord,
So
affidavit.
they have not filed any objection. How they can say, last time, several times they took time for filing objection. Kindly see the last orders.
Have you filed your objection?
No.
No file, not file
My lord,
objection.
on 14/6, my lord, this honorable court, my lord, this I am, my lord, for consideration. my lord.
That's why you'll have to file your objection if you want to object. Are you filing or not?
Like that 3 weeks, 2 weeks may be granted, my lord, for filing of.
Okay. But M.E. Mahmood, then the counsel for the petition. Mr.
Ellen Ding, my lord, respondent number 5.
Mr.
Ellen Ding, my lord.
Ellen Ding, then the council appearing for respondent number 5, this about 2 weeks time. To file objections to the present. Oh, don't say petitioner, also say applicant. List the matter up to.
Obliged.
Obliged.
14 hearing, part of matter.
Mr. Nayak is on legs in court number 1. All this while he was here, Lordship.
He can do her part.
He's doing his submissions, Lordship. Lordship asked me to bring the cabinet approval, Lordship. I have got the copy of the cabinet approval.
What was this matter about?
This matter was about, we were employees of the erstwhile, my lords, Assam Agro Industries Development Corporation, Limited, my lords. After the closure of the corporation, we were asking for absorption in the agriculture department. Finally, we were absorbed, but some of our benefits have not been paid so we are agreed by that, and we are praying for such benefits in this edition, my lords.
So Nayak has to answer that.
Yes.
Where's
He-
Nayak?
He had in fact completed his arguments.
Completed his arguments, Lordship.
He was only,
He
I
was to
suppose,
place his judgment.
yes,
Lordship.
right.
Where is he?
And Lordship wanted me to bring the cabinet approval, Lordship. I have got a
That,
copy.
that
of
I'll
the-
come back to you.
Yes,
That
Lordship.
I'll-
Yes, yes.
When is he coming?
He'll be come.
Okay, we'll check up, we'll wait for some time.
Obliged.
15 and 16.
The last occasion, my lord, the Dibrugarh University is supposed to, my lord, submit the decisions on their part, my lord.
Where is the Dibrugarh University? Where is R. Majumdar?
The last occasion, Lordship, the University Council is directed to take the decision of the university.
No, they said that they are considering your case.
No.
Isn't that?
Yes.
That Dibrugarh University is considering the case of the petitioner.
Yes.
And wait for some time to enable him to get an updated instructions. Where's Majumdar?
This is Majumdar is the- Because virtually in my case, it is attend of 15. If regarding the perspective of retrospective of the order of the voluntary retirement, they have agreed on that point, but they have taken one to instruction from the university. That is only, if they take the instruction, then madam, maybe they close it.
Wait for something.
Yes.
Seventeen.
May I please, your lordship?
Raghu, you are ready today? Last occasion also you took that.
No, my lord, they are not coming, my lord. Last 3 occasions, their name shown, my lord, I have also personally requested, but they have not turned down. Cause list is continuously reflecting their name, my lord. DA Kayum and other colleagues for private respondent, 5, 6, and 7 appeared, my lord. And other, my lord, may can verify, they have filed wakalatnama for 5, 6, and 7, my lord. Therefore, service was completed, my lord. Initially, they uses to appear, my lord, but later part, my lord, they have stopped, my lord. A very old pending matter, my lord, from 2014, this person is, my lord, with a hope.
What shall we do?
And my lord can hear, my lord, they are not coming, my lord, perhaps some instruction they are not.
Or shall I pass the next party or? send
Next
the-
party, my lord,
If
can,
next time they are not appearing, we'll proceed next party.
last 3 occasions, they
That-
have not turned down, my lord.
That occasion, that chance may be given.
My lord. Then that observation may, my lord, may be pleased to record, my lord. The matter of, my lord, termination by the managing committee, my lord. And later part, my lord, this petitioner has also been deprived of the benefit of provincialization, my lord. Now, in the instant case, my lord, I have challenged the resolution of the managing committee as well as my termination, my lord.
Heard Mr. Yabuyan and contributed. Also heard Mr. J. Pikul and a standing doctor argumentation. None appears for the respondents, 5, 6, and 7. This the matter I can on. When do you want?
My lord, next Thursday, my lord.
Give the
31st.
this the matter I can on.
31st, my lord.
31st.
My lord.
If the respondents 5, 6, and 7 are not responding visited by the next. Difficult shall proceed ex parte.
Fine. Obliged. Obliged.
18.
18 to the Rehana Begum. My lord, in this petition also, my lord, there is a private respondent, my lord, is there. Here is also a, my lord, similar nature of case, my lord, that the petitioner, my lord, had been working as an graduate assistant teacher, my lord. And later on, my lord, her services had been used to be terminated, my lord, which when I filed this writ petition, my lord, then I could learn, my lord, that some notices, purported notices had been shown to be issued to the petitioner, my lord. Actually, I have never received any notice. And on the allegation of unauthorized absence, my lord, my service had been terminated without following the due procedure of law, which is, my lord, find place in the 2006 Act and 2007 rules, my lord. Our lordship is well aware, my lord, section 15 of the 2006 Act, my lord, is applicable for these categories of employees.
Therefore, my lord, this, the full bench of this honorable court in the Abdul Ghaffur Mandal's case, my lord, in paragraph 48 says that if the statutory requirement for these categories of institution is not followed, then, my lord, the writ petition is maintainable and it can be decided on merit, my lord. But, my lord, this private respondent has entered appearance on in the last occasion also, but they have not turned down today also, my lord. This is first time come up for hearing, my lord, so a chance may be given to them also, my lord, fixing a date, my lord.
But yeah, Bhuyan and also petition.
I'm for secondary education.
Also heard Mr. U Sharma and standing for the secondary education department. And Mr. R. Salui, Leonard Council for the respondent. You are the government advocate. Yes, yes. Okay, Mr. R. Salui and government advocate applies for respondent. Non-appears for the
Respondent 4, 5, and 6 minutes, 6
4,
to
5,
7 minutes.
6 and 7. Is the matter again or give them some time?
My lord, on first week of September, my lord.
First week of September is practically a holiday.
Then, my lord, on 12th of September, my lord.
Yeah, so
My lord. Oblige, my lord.
19 and 20.
In item 19, I have instruction to withdraw the matter. Over 20, Mr. UK Nair is appearing, he is on his legs in court 1, lordship. If possible, can it be fixed next Tuesday?
item 19,
19, I wish to withdraw.
11210. Item 19. Mr.
A. Kakoti.
A. Kaputil, council. To the petition. Request for withdrawal of this. Anybody appearing in item 19? You appearing, Tabildar? You see here, Tabildar, standing council higher education appears for respondents, 1, 3, 1 and 3. And MS. Standing council UGC appears for respond number.
Yes,
5. Petition is accordingly dismissed. And in item number
20, lord.
20, on request for on behalf of Mr. Yukin, senior counsel to the petition. Please stop the one.
Deeply obliged, lord.
21.
In this case, my lord, 2 weeks may be granted, my lord, to receive instruction whether the parties, my lord, pursue the matter or not, my lord. Long pending matter, my lord.
Okay, Mr. K. Patkiril and a council petitioner press for 2 weeks time to enable him to receive instruction. Yes, allowed. Please stop to 2 weeks.
My lord, obliged.
22 and 23.
May I please, your lord? My lord, this is an old matter, my lord. What has happened, my lord? This is regarding the charge of holding the charge of an upper primary school, my lord. But subsequently, I have lost interim order was there, my lord. By virtue of the interim order, the petitioner was holding the charge in that particular school. Thereafter, my lord, I have lost contact with the petitioner, my lord. Perhaps he had get some relief also from the government. Now, my lord, may I pray, my lord, 10 days time will be given to take the updated instruction, my lord.
On request made by Mr. A. Council. This matter 2 weeks to enable.
Well, obliged.
24.
May I please, your lordships, the petitioner before your lordships, they are the Hindi teachers. They were provincialized in the year 2013. Then thereafter, my lord, their service was deprovincialized.
Your additional affidavit has come.
My lord, we have submitted 5.
When did you file your additional? Yes.
3-8. Fine. Impin order is at page 74, man. Our service was deprovincialized.
1 minute. Who appears for respondent?
I am for the.
Yes.
Only ground is that there is no student in Hindi.
Which?
Page 74.
There are two page numbers.
Annex 17, page 74.
Annexure
17, 17.
What is that? Is in order?
My lord. The provincial last paragraph. Hence, the provincialization order issued by this director in respect of the following teachers are hereby withdrawn.
This annexure?
Page 74, last paragraph.
No annexure?
Page Annex 17. My.
Yes, who is the petitioner? All these are.
My lord, these five petitioners below.
Then
No notice, my lord. No inquiry. Our provincialization has been withdrawn. And on similar issue, my lord, the number of cases have been filed. And on all 10 cases were filed. My lord. And I have annexed one of the judgment order, my lord. I have filed by way additional affidavit also.
1 minute. Who is your additional?
That is filed on 1811.
Similar facts.
Same, similar, my lord. And
Who is the order?
that is 1811-2021. We have filed one affidavit. And these are the bunches of this disposal order, my lord. In addition, affidavit earlier I filed. Only same show cause notice was issued to us. Here also same show cause notice in different school and different district.
Are you having a stay order?
My lord. We are continuing.
Yes.
All the cases have been disposed of. That notice was challenged here. And that notice also, my 19/11/2014, here also 19/11/2000 notice was issued, we replied, then
Where's the notice, not 1911?
yes. I have annexed that notice also. That is at page 70 to 71,
Page?
page 70. Nineteen 2014. Here in these similar cases also that notice was issued to different. Only ground that there is a lack of student in Hindi subject.
Notice. All same date,
Same date.
notice.
19/11/2014.
Here, my lord, petitioner is five, my lord.
Hmm.
5 numbers of petitioner, but notice they have annexed, my lord, only one. From respondent for petitioner number 1. And the rest are not annexed here, my lord.
After notice, what happened?
There, my lord, this
You file your reply.
I have filed it.
After that, what happened?
Nothing.
Then you pass the order.
Yes.
No disciplinary proceeding, nothing.
No.
Yeah. What more can we do? And is this a ground that if there are no students, that their services will be deprovincialized? Is it the fault of the petitioner?
My lord, otherwise, my lord, here during the time of provincialization, here it is stated, your service have been provincialized on the basis of the particulars submitted by the superintendent of the High Madrasa as well as you for your personal gain and benefit and misuse the misuse of government money. You are therefore charged with misuse of government money. And my lord, statement of allegation, next page 71. That while you were working as Hindi
No, what
teacher,
happened after this? What happened after this?
the order was passed, my lord.
Was there disciplinary proceeding
Yes.
drawn up? You issue show cause notice, he answers to the reply, then you pass the deprovincialization order. Can you sustain that? And supposing if the petitioner is, he has been provincialized,
Yes.
correct? He has been deprovincialized on the ground that there are no students, no Hindi.
Right.
Can that be a ground? Is it the fault of the petitioner?
Section 19, some discipline. So, my lord, kindly remand back to the appointing authority so that examine the matter.
No, what happened after you filed your additional affidavit?
That in that particular school, Hindi students are there. That on that point, my lord, we have filed affidavit.
That's all.
That's all. Now that ME school is tied with the high school, so there are some students on this part.
Okay. Give me the facts.
My
Hurt Mr.
N Hawk, my lord.
N Hawk, learners counsel for the petition. Also hurt Mr. U Sharma, learners standing counsel. Secondary education,
Yes, for respondent number,
for all the respondents.
all the respondents.
Well. The petitioners were all initially appointed as Hindi teachers. In which madrasa?
The petitioner number one, well, page 74 may be seen last. No, no, I'm giving it.
Oh. Under different madrasa.
Different ones.
In the district of
Nagaon.
now. Stop. In the year? Between the year
2030.
between the year 1990.
It is answer.
At that point of venture. 1990 to 1993. Page 7.
94, 2004. Between the years 1990 to 1990 to
2009, up to 2009.
between the years 1993 and 1990 to
2009.
Stop. The services of the petitioners were drafted, provincialized. Where's the order of provincialization?
Page 45. It starts. 3 June 2013. Runners of 3 June.
All the petitioners' name are here.
3 June 2013. Third June.
Were provincialized by orders dated by different orders, all dated 3rd June.
3rd June.
2000. The petitioners in the present writ petition is assailing the order dated 30 June 2015, by which the petitioners who were already provincialized in their respective posts as Hindi assistant teachers. Hindi assistant teachers.
Assistant teacher Hindi.
In their respective schools have been revoked by stating that their claim for provincialization has been rejected. No. Whereby the provincialization orders issued by the directorate were withdrawn. Stop. Were withdrawn on the ground that no students opted for Hindi as MIL in class 10. Stop. Alright. It is the case of the petitioners that their services were provincialized, that they were provincialized in the respective course under the different schools or
Right.
madrasas.
Now school, earlier madrasas.
When you are provincialized, it was a school
It was
It was
madrasa.
madrasa.
in the respective madrasas. On which date was it? 3rd June
13.
2013. By following the due process of law. And as per rules. And therefore, the question of withdrawal of their provincialization orders does not arise at this stage, as the same amounts to termination of the service,
I know.
correct? Termination
Right.
of this. Stop. The further case of the petitioner is that they were issued with show cause notices, all dated same,
Yes. Same.
dated 19th November 2014. Under Rule 9 of the Assam Services within bracket discipline and appeal close bracket rules 1964. Stop. The petitioner's drafter replied to the said show cause notice. Stop. However, without proceeding any further in terms of the provisions of the rule, Assam, within bracket, we say rules of 1964 and 60. Without proceeding in terms of the rules of 1964, the order dated 30 June 2015 was, the impugned order dated 30 June 2015 was passed. Stop. But it is undisputed that the petitioners were appointed, that the service of the petitioners were provincialized after following the due process of law. Stop. Therefore, comma, stop. The benefit of provincialization is sought to be taken away by the state merely on the ground that no student in the Hindi subject is available in the said schools. Stop. Lack of students in a particular subject cannot be a reason for revoking the provincialization of the petitioners. Stop. Further, comma, after the show cause notice dated 19th November 2014 was issued, and thereafter the petitioners replied to the section of notice. Nothing proceeded any further. In accordance with the rules of 1964. And the impugned order was merely passed on 30 June 2015. Stop. A perusal of the order dated 30 June 2015 further indicates, also indicates that as no students opted for Hindi as MIL, the provincialization orders of the petitioners were withdrawn. The respondents cannot nullify the provincialization of the petitioners in the manner that has been sought to be done by the impugned order dated 30 June 2015, except by resorting to the process that has been laid down. No, except by resorting to process. Except by resorting to lawful process. Stop. This court therefore is of the considered opinion that the provincialization of the services of the petitioners cannot be taken away for the reasons mentioned in the impugned order dated 30 June 2015. Stop. In that view of the matter, the provincialization order, the impugned order dated 30 June 2015 is set aside in question. Stop. Para. The impugned order dated 30 June 2015 was stayed by this court by order dated
26/8/2015.
Okay, anyway, you are continuing.
Yes, I'm continuing.
Then there's no problem. Cancel that. Set aside in court. It is directed that the petitioners shall be provided, shall be allowed to continue in service.
And if it is remanded back to the director, then
I'm not remanding it back. This is a very long order you passed. Okay, I set aside in court. With petition is accordingly allowed.
Obliged.
Fourteen.
Nayak, how long you'll take?
Not much, Lordship. Half an hour will be sufficient.
Then we don't have time. I'm rising at 4.
Lordship. Otherwise, also, Lordship, if they think that they have completed, Lordship, they will not come again after completing my argument, Lordship. Then Lordship will go for one final hearing, Lordship. So, convenient to your Lordship.
You are going to give a reply, isn't it? Are you giving a reply?
we would like to give a reply, Lordship.
Then we'll fix a different date. Today just no time. Heard, Mr.
S. Bishop.
S. Vishwakarma, Learned Counsel for the petition. So, also heard Mr. P. Nayak, Learned Standing Counsel Finance Department. And MS.
Arbora.
Arbora.
For the agriculture department.
Standing Counsel Agriculture. List the matter for further hearing. On, wait, give a date.
On 7th of September, Lordship?
Not 7, Lordship will give us some sufficient time, Lordship, so that matter comes earlier, Lordship. Otherwise, it will come again at the end of the matter, end of the list. Lordship can take up this matter in the month of October.
October will be too late, Lordship.
October will be too late.
In the first week of October, Lordship.
September will have it. We have it on 19th September.
Can it, oh, so it is fine.
Lordship, I'll be submitting my written argument for convenience to your lordship.
15 and 16.
Oblige was.
What is the last submission you said? that-
Yes, I will, it has been placed before the VC, my lord. It has been forwarded to the EC now, the Executive Council, my lord.
Oh.
It will take maybe a week more, my lord, time to reach my children. They're perhaps getting the relief. That is what the impression I have been given.
Can you
Lord,
wait for 1 week to get the relief?
We can wait, my lord, and if nothing is materialized, your lordship can fix a date on 19th September. My lord, if we are not happy with the, my lord, negotiation, the lordship may hear the entire.
But Mr. BP Barwa, London Council for the petition in WBC 7540 of 2017. As well as Mr. S. Tata, London Senior Council, assisted by MA
Yes, Mushari.
Mushari, London Council for the petition in WBC 5044 of 2017. Mr. R. Magunda, London Standing Council, Dibrugarh University submits that
A week more will be.
that the case of the petitioners
Is under consideration.
is under consideration and has been placed before the executive council. He therefore prays for some time to enable him to receive instructions. List the matter on 19.
19.
19 is what? 19
Your lordship fixed the matter as part heard earlier, so.
as part.
All right. Complete.